So I'd like to welcome everybody to the final trial of the 2020 In Vino Veritas National Mock Trial Competition. Right now we're going to get started with the final trial. First, I'd like to introduce our presiding judge, which is Judge Victoria Kolakowski. And we do have our bailiff here is going to read her bio and her introduction. So Keenan, why don't you take it away?
Absolutely. Good morning, everybody. Victoria Kolakowski made international headlines in November 2010 when she was elected as the first openly transgender trial judge in the United States. As a judge, she has served in both civil and criminal trial assignments. She's passionate about ensuring and expanding access to justice, particularly for those with limited resources. She serves on the Judicial Council of California's Advisory Committee on Providing Access and Fairness, and is the California Council of Churches appointee to the California Access to Justice Commission. She is a former president of the International Association of LGBTQ+ Judges and of the Earl Warren American Inn of Court chapter. She was an attorney for 21 years in Louisiana and California, serving as a sole practitioner, attorney in a small firm, as a general counsel for a publicly traded company, as a senior government utility regulatory attorney, and as an administrative law judge for 2 different California agencies. So without further ado, all rise or constructively for the Honorable Victoria Kolakowski.
Thank you, Keenan, and thank you, Judge. I'll let you take it from here.
Okay, and I just want to point out again on the record, what I said before we were off the record was my virtual background says do not record. I understand that we are being recorded. Indeed, I have watched some of the video of previous competitions, and so I'm well aware of that. Now, just one second. The rules have been discussed before. We were off the record, and we are going to be proceeding at this point. Calling the matter of United States versus Sharon Saxon. Would counsel state their appearances?
Yes, good morning, Your Honor. My name is Elizabeth Hersey, and along with my co-counsel Holly Speece, we represent the United States, and we are Team I.
Okay, and for the defense?
Good morning, Your Honor. My name is Russell Munilia. That is spelled M-O-N-I-L-L-A. And together with my co-counsel,
Marissa Vera, last name spelled V-A-I-R-O.
We are Team B, as in boy, and we represent Ms. Sharon Saxon in today's proceedings. At this time, Your Honor, we have some preliminary matters that we would like to take up with the court.
Yes, you may.
And Your Honor,
oh,
excuse me, we also have a few just so the court is aware.
Okay, I'll start with the defense. We'll go to the prosecution. I'll hear all of this. Thank you.
Your Honor, for timing purposes, may we assume that all arguments are heard at constructive sidebar?
Yes.
May we assume that all witnesses are constructively sequestered except for the defendant today?
Yes.
And due to the unusual nature of today's trial, may we be allowed to briefly turn off our camera as we set up our virtual well in order to minimize distractions?
Is there any objection?
No, that's fine with us, Your Honor. We'll be switching between cameras too.
Okay, then that's fine for both sides then.
Thank you, Your Honor. We would also like to put the court on notice that, again, due to the unusual nature of this trial, my co-counsel and I will be communicating through our cell phones.
Absolutely, I understand.
We would also like to put the court on notice that we will be wearing AirPods in order to filter out noise and sound that might occur during the trial.
That's perfectly understandable.
And further, we would like to put the court on notice that there will be certain pieces of hearsay statements that defense will not be objecting to pursuant to local rules of the competition, specifically 17 and 18.
Okay.
And with that, Your Honor, we are ready to move forward.
Okay, from the prosecution, you had was there anything that the defense did not cover that you wanted to bring to my attention?
Yes, Your Honor, just a couple of things. And first, just to put the court on notice, there have been a number of stipulations reached in this case, and I'd like to point out a couple of those for the court's attention. Now, for a little bit of context, to these stipulations, The alleged crime in this case did take place back in the year 2000, and it was a cold case for 20 years until now when it is being brought forward. Per Stipulation 7, Jamie Smith, who is the son of the victim John Smith and the defendant Sharon Saxon, is unavailable to testify at trial as he now resides in South America. And he did testify in the preliminary hearing, and per the stipulation, teams are free to reference that testimony. We do intend on reading in a portion of that preliminary hearing transcript at the close of our case in chief.
I understand. And so I'm aware of the various procedural and substantive stipulations that have been reached, and I have a copy here in front of me. And so I also want to point out, speaking of the unusual nature of all of this, that we're doing this all virtually, electronically. This is something that is unfortunately a reality of conducting even trials in our current day. And it's unfortunate, but it's a reality. It's also possible that somebody could encounter technical issues. I hope that does not happen. The bailiff has put some information in the chat. I would recommend that you perhaps take that information down now before you have the technical problems, because you may not be able to access that information should there be technical problems. And so, and we will understand that. We'll make appropriate adjustments for it. There are contingencies in the rules for the proceeding for how to deal with these technical problems. But I'm hoping that, especially on a, I'm going to say beautiful Sunday morning, that we won't have nearly the same problems that we might have on other days when there might be a higher volume of internet usage and things like that. So with that all being said, is there anything that we need to discuss prior to the opening of the case?
Your Honor, I actually just had two more brief preliminary matters to take up with the court.
Okay.
First, Your Honor, we do intend on using PowerPoint during opening and closing, and we have conferred with the defense counsel on the opening PowerPoint, and it's our understanding that they have no objections to the exhibits that we will be using in that PowerPoint, as we do have a good faith basis that's coming in, and we have prepared a redacted version of one of the exhibits that we understood defense did have an objection to.
Okay. And is that true from the defense, that you've met and conferred on this, and that the PowerPoint's acceptable?
Yes, Your Honor.
Okay, great. And so, was there anything else from the prosecution?
Just one final preliminary matter, Your Honor. The exhibits in this case have been pre-numbered 1 through 18, and we do intend on referring to those as 1 through 18, and the table of contents can be found on page 4 of the case packet.
Excellent.
And with that, we're ready to proceed to opening statements.
Okay, is there anything else that the defense has before we begin?
No, Your Honor, at this time we are ready to proceed.
Okay, and so, and now again, I understand that this is an awkward situation in terms of timing. It's I think easy sometimes for us to step over each other when we're speaking. I understand that. There's no need to apologize if you do so. I understand that. Also, I want to point out that it is my general policy that if the reporter has any problems with speed or understanding what any of us are saying, that they are always encouraged to interrupt. Including interrupting the judge. I want to be clear to the reporters that it is perfectly fine to interrupt the judge if she's talking too quickly or not clearly enough. Okay, so with that being said, let us proceed to the opening statements, and with that, we would begin with the prosecution, the people.
Thank you, Your Honor. May I have one moment to set up the virtual well?
Yes.
Can you see me okay?
Yes, yes.
May I proceed, Your Honor?
Yes, you may.
Thank you. Today, we're going to go back in time. We're going to go back 20 years to the day the defendant decided her husband had to disappear, but his money had to stay. On March 6th of 2000, the defendant was inside of her home on their wildcat sanctuary. She was waiting to talk to her husband. They'd met years earlier, and when they did meet, he was a wealthy, married man, but things between them, they hit it off, and everything was good. But recently, they'd been fighting, both frequently and ferociously. And the defendant had caught wind on that March 6th day that her husband was going to leave her and take his money with him. And as she was waiting to confront him, she realized he was not coming home. So she texted him, "I know you've been meeting up with our lawyers. I know you've been going behind my back." And despite the victim's adamant denials, it was too late. The defendant had already made up her mind. She texted John, "You want to see crazy? I can show you crazy." On March 6th of 2000, the defendant decided her husband had to disappear, but his money had to stay. Years earlier, when they had met, their marriage was going well. They had opened up a perfect place. It was a wildcat sanctuary. And although their business was quite lucrative and successful, the differences between this couple could not be ignored. Where the defendant had grown up with little means, Mr. Smith was a multi-millionaire. And where the defendant was an anti-cat breeding activist, Mr. Smith believed breeding cougars would save the species. And over the years of their marriage, these differences began to eat and eat and eat at their relationship until there was nothing left but a failed marriage. But the defendant wouldn't give up that easily. So she approached her husband. And she told John, "Please, would you stop breeding?" But he refused. So she asked him again and again, and each time he denied her, an anger began to well up inside of the defendant until she decided she wouldn't take no for an answer. So in 1999, she told her husband, "If you don't stop breeding cougars, I will shoot you." Now, this concerned the victim, and he reached out to his son. And on March 4th of 2000, he let him know that the marriage just hasn't been the same, but no matter what, he would always be taken care of. But this promise would not be kept. It could not be kept, because 2 days later, on that March 6th day, the couple had the fight where the defendant decided that their marriage could not be salvaged. And she had worked too hard to lose the wealth that she never had growing up. On that day, she decided her husband had to disappear, but his money had to stay. So she went to work, and on March 12th, 6 days after this fight, she went to a hardware store and purchased 4 key items: sardine oil, black leather gloves, 4 gallons of bleach, and a heavy-duty tarp. Everything she would need to make sure her husband would disappear. Then she acquired key documents on March 15th of 2000. She obtained her husband's power of attorney and will and his marriage record. And she began to trace the signature on these documents onto a new power of attorney that she amended to read, upon her husband's disappearance, she would gain everything. She made sure her husband's money would stay. Everything was prepared. She had everything ready, and all she needed was the perfect opportunity, which presented itself on March 18th, when her husband had a trip planned to go to Mexico City. Now, he was set to leave early in the morning, and she went to work. The sardine oil that she purchased on March 12th, she strategically placed on her husband's body and neck. And this oil is so potent that the smallest or the largest cougar would be blinded with their hunger. And after putting this oil on him, she got him into the cage of the most ferocious cougar on the property, Malbec. And as Malbec was feasting on John Smith's body, his blood began to splatter on the inside bars of this cage. And after he was eaten, the defendant gathered what was left of her husband and fed it through an industrial strength meat grinder, taking the contents and distributing it to the cougars on the property. Then she washed away her massacre with that 4 gallons of bleach. Now all she had to do was cover her tracks. So she hid that sardine oil deep inside of her own home. And she hid the ring deep inside of a storage unit on the sanctuary. And then she reported her husband missing the same day he was set to leave. She played the role of the grieving spouse, all the while taking $10 million and transferring it into her own personal bank account. And for 20 long years, she has benefited from the fortune and the fame that she gained upon her husband's disappearance. But after 20 long years, the tracks that Sharon Saxon attempted to cover led right back to the sanctuary, and the Department of Justice caught wind of Mr. Smith's suspicious disappearance. They discovered blood on the inside of that ferocious Malbec cougar cage. That blood belonged to Mr. Smith. They also discovered the defendant was out at 3 o'clock in the morning on the same day her husband was set to leave on an early morning flight to Mexico City. And when they began to investigate, it was discovered that John's car was at the airport hangar with his passport, cell phone, and wallet. Everything he would need to take a trip to Mexico City. Now, members of the jury, we are here today because the Department of Justice and the police realized after 20 long years that Sharon Saxon murdered her husband for financial gain. And as the prosecution, we bear the burden of proving this crime to you. And we welcome that burden because at the conclusion of today's trial, my co-counsel, Ms. Hersey, will review all of this evidence. And it's at that time you will have no doubt. Sharon Saxon decided her husband had to disappear, but his money had to stay. Find her guilty. Thank you.
Okay. At this point, the defense may, but is not required to present their own opening statement. They may instead present it at the end of the prosecution's case because the prosecution has the burden of proof in this matter. And so is the defense going to be providing an opening statement at this point?
Yes, Your Honor. Just a brief moment to reposition the virtual well.
Yes.
Thank you. May I proceed?
Yes, you may.
May it please the court, opposing counsel, members of the jury. You just heard the state's opening statement. And by now, you know the reason that you're here is because in March of 2000, Mr. John Smith went missing. And the state is going to try and convince you today that Mr. Smith vanished because Miss Saxon killed him. However, the state will only be able to present you with conclusions based on unreasonable and flawed assumptions. They will not be able to present you with important, definite evidence to support their case today. Good morning. My name is Marissa Vera, and I, along with my co-counsel, Russell Manelia, have the honor of representing Ms. Sharon Saxon in today's case. This case begins and ends with a love of cats. And I don't mean small little house cats. No, I mean big cats. Cougars, to be exact. And that love for the wild things in life is what drew Miss Saxon and Mr. Smith to one another. In fact, you will hear today that Mr. Smith gave Miss Saxon a baby cougar as her wedding present. Their relationship was built on a desire to rescue cougars from horrible treatment, life in small cages, exploitation for entertainment, and even exploitation for their furs. This dream manifested itself in their sanctuary, a place where their passion for big cats could be used to make a difference. They built a perfect place together, not only as a rescue, but as a way to better inform our community. Now, I'll be honest with you, members of the jury. Sharon and John, they had low points in their marriage, as all couples do. And there's no denying that in March of 2000, Mr. Smith went missing. Now, this is the point in the case where the facts stop, and you will see that the unreasonable and flawed assumptions take over. This is where the state began its collection of uncertain information, looking for someone to blame. And they chose to point their fingers at Miss Saxon. To be clear, the state has the burden today to prove to you beyond a reasonable doubt that Miss Saxon murdered her husband and that she did so for financial gain. Now, what do we mean by that? Beyond a reasonable doubt. Beyond a reasonable doubt is a standard that requires far more than a guess or an inference. Make no mistake, members of the jury, beyond a reasonable doubt is one of the highest burdens in our criminal justice system. And with such a heavy burden, the prosecution must have the facts and the evidence to meet that burden. You will see today that they do not. At the end of the day, you must make the decision in this case. And that decision cannot be based on flawed assumptions alone. The state will attempt to justify its case today through the evidence of Mr. Rick Wilde, which you will hear from. Mr. Wilde is someone who is also in the big cat business. And to say that he has a passionate hatred for Miss Saxon is an understatement. You will hear Mr. Wilde tell you today that Miss Saxon murdered her husband based on biased assumptions that he himself made. Mr. Wilde has no direct knowledge of the allegations that he is making against Miss Saxon. You will not hear today that he witnessed anything. And unfortunately, his biased assumptions influenced the investigation that was done in this case. The state will also call to testify Detective Tiffany Hanson. You will learn that Ms. Hanson took over a 20-year-old case and that she based her conclusions on a blood sample, a singular fingerprint, and the biased assumptions of Mr. Wilde. You will see that Ms. Hanson arrested Ms. Saxon based on this small shred of evidence alone. You will see today that Ms. Hanson made incorrect conclusions based on incorrect assumptions. Then you will hear from our witnesses. And we will not jump to conclusions. We will present you with concrete facts and evidence to support our case today. First, you will hear from a Detective Blair Pickus, who did an investigation in this case. You will learn that Mr. Pickus has 25 years of experience and that he specializes in homicide investigation. Detective Pickus will tell you that through the course of his investigation, he has come to know that Mr. Smith fled to South America in 2000 and that he is alive today. Detective Pickus will tell you that Mr. Smith occasionally used an alias, Richard Spaulding, and that he found a Richard Spaulding in South America with the same birth date as Mr. Smith. And even more, that Richard Spaulding has been identified via photograph to be Mr. Smith. Members of the jury, you are going to see pictures today of Mr. Smith alive and well in Caracas, South America. Because of that, Detective Pickus will tell you that Miss Saxon committed no crime. Finally, members of the jury, you are going to hear from Miss Saxon herself today. Now let's be clear about something. We as the defense, we have no burden. We do not have to do, say, or prove anything to you here today. My client has a right to remain silent. But members of the jury, she is giving up that right here today. Miss Saxon is going to take that stand to show you that she did not commit the crimes that she has been accused of. You will learn today that no one knows for certain what happened to Mr. Smith. And neither does Miss Saxon. But she will tell you for certain what did not happen to him. She will tell you with certainty that she did not kill Mr. Smith. And that is the correct conclusion in this case. Members of the jury, I ask that you hold the prosecution to its burden today. A person's freedom should not hang in the balance because of conclusions based on unreasonable and flawed assumptions. I ask that at the end of this trial, based on the evidence, that you render the only just verdict and find Miss Saxon not guilty. Thank you.
Okay. The jury has now heard the opening statements from the people as well as from the defense. And so now we're going to be moving on to the presentation of evidence. Is the prosecution prepared to proceed?
We are, Your Honor. At this time, the people call Investigator Tiffany Hanson. May I proceed, Your Honor?
Yes, you may.
Good morning, Investigator Hanson. Could you please introduce yourself and spell your last name for the record?
Yes, my name is Tiffany Hanson. That's Hansen.
And Investigator Hanson, what is your connection to this case?
I work for the Department of Justice and was brought in to investigate John Smith's disappearance.
Now, who is John Smith?
John Smith was married to the defendant, Sharon Saxon, and they owned a Perfect Place cat sanctuary together.
And when did Mr. Smith disappear?
He was reported missing on March 18th of 2000.
Now, without going into what that conclusion was, were you able to come to a conclusion about what happened to Mr. Smith back on March 18th of 2000?
Yes, I was.
Now, before we get to that conclusion, I want to talk a little bit about your background and let the jury get to know you. So what do you do for a living?
I work for the Department of Justice. I've been there for 10 years.
And what is your specific role at the Department of Justice?
I work on homicide investigations, specifically cold cases.
And what sort of training did you have to go through to become a cold case investigator?
I went through some special training in criminal investigations through the Department of Justice.
And in your time with the Department of Justice, how many cold cases have you investigated?
Just over 200.
And what makes a cold case different from an active homicide case?
Yeah, so typically cold cases are a little bit older. When the crime first occurred, the police do investigate, but for whatever reason, a lack of evidence, a lack of leads, they're not able to make an arrest, and so the case stays open and just goes cold.
Now, turning to this case, what did you review and what did you do in your investigation into the disappearance of John Smith?
Yes, so I started by reviewing the case file from 2000, and I considered the evidence that was collected back then, and then I was actually able to collect additional evidence now in 2020 and talk to several witnesses.
Now, you mentioned a case file from back in 2000. Was the Department of Justice investigating this case the whole time?
No, when John first went missing back in 2000, it was the Napa County Sheriff's Department that investigated.
Now, in the course of your investigation, did you apply your training and experience?
Yes, I did.
And is your training and experience investigating cold cases the product of reliable principles and methods?
Yes, it is.
Counselor, can you speak slower?
Certainly.
Thank you.
Is your training and experience the product of reliable principles and methods?
Yes, it is.
Your Honor, at this time, the people move to tender Investigator Tiffany Hanson as an expert in cold case investigations.
Okay, does the defense wish to keep water?
We do, Your Honor. Just a brief moment to reposition. May I proceed?
Yes, you may.
Ms. Hanson, can you tell us what type of educational background you have?
I've just been trained in criminal investigations through the Department of Justice.
So you do not have any degrees relating to criminal justice?
No, just lots of experience.
Can you tell us what type of training specifically related to cold cases you have?
Well, in addition to all of my experience, I mean, the training for cold cases is very similar to what it is for homicides. It's still talking to witnesses, it's still collecting evidence, it's still following leads.
Do you have any specific certifications related to cold cases?
No, no specific certifications.
Ms. Hanson, have you ever written any papers about cold cases and been peer reviewed?
No, I have not.
Okay, and have you ever taught any courses relating to cold cases?
No, I don't teach, I actively investigate.
Okay, thank you, Ms. Hanson. Your Honor, at this time, we would object to Ms. Hanson being tendered as an expert as she does not have the correct expert qualifications.
I'll hear from the people on that.
Yes, Your Honor. The standard under 702 for a witness to be tendered as an expert is that their scientific, technical, or other specialized knowledge would help the jury understand the evidence. This witness has testified that she has over a decade of experience investigating cold cases and has investigated nearly 200 cold cases and was trained by the Department of Justice in criminal investigations. Her qualifications, while she hasn't taught courses or have formal college degrees in criminology, meets the standard under 702.
Okay. Anything else from the defense on that?
Your Honor, we would stand by our previous argument.
Okay. I'm going to admit this witness as an expert, and the people may proceed.
Now, Investigator Hanson, I want to talk a little bit about some of the problems with that investigation back in 2000. Now, what happened with the investigation back in 2000 from the Napa County Sheriff's Department?
Yes, so they began investigating when John was reported missing, but they really only looked at a few things and then quickly decided he fled to Costa Rica, and they didn't look for him there, and they just stopped investigating and the case went cold.
So when did you first begin investigating this case?
I began investigating in February of 2020.
And when you first started investigating this case, what did you do?
The very first thing I did was review the evidence that was collected back in 2000.
And what evidence was that was collected in 2000?
Well, notably, there was some blood DNA collected off the Cougar cages.
Where specifically on the Cougar cages was that blood collected from?
Yeah, it was found on the inside bars near the entrance, as well as the feeding slot for the cage for Malbec and Zinn.
And who are Malbec and Zinn?
They are two of the cougars on the property, Malbec being one of the more aggressive cougars.
And was there any kind of testing done on this blood to try and determine who it belonged to?
Yes, there was. It was tested back in 2000, but the technology just wasn't what it is today. But as part of my investigation, I did retest it and get results.
What were those results?
It came back as a 100% match to human blood and a 90% match to John Smith.
Wow. So was there any other physical evidence collected back in 2000?
Yes, there was also a meat grinder collected from the property.
Now I want to turn your attention to Exhibit 7. Let me know when you have that in front of you.
Yes, I do.
What is Exhibit 7?
This is that meat grinder that was collected.
How do you know that's the meat grinder?
Because I reviewed it as part of my investigation.
And is that a fair and accurate representation of what the meat grinder looks like?
Yes, it is.
Your Honor, at this time, the people move Exhibit 7 into evidence.
Any objection?
No, Your Honor.
Okay, that'll be admitted into evidence.
And permission to publish via the share screen.
Yes, you may.
Now, Investigator Hanson, was there any kind of testing done on this meat grinder?
Yes, there was, and it came back as having only bleach on it.
Thank you, Ms. Spees. Now, is there any other physical evidence found as part of this initial investigation?
Yes, the Sheriff's Department also located John Smith's car at the airport, but it still had his wallet, his phone, and his passport still inside the car.
Now, is this all of the evidence back in 2000 that was collected?
Yes, it is.
And was that enough to come to any kind of conclusion?
No, it wouldn't be, especially not having the results from the DNA yet.
So then what did you do in your investigation to try and uncover some new evidence?
Yes, I was able to actually search the sanctuary property and find some more physical evidence that was missed back in 2000, as well as talk to some key witnesses.
And after conducting your investigation, what conclusion did you come to about what happened to John Smith back in 2000?
Well, the evidence showed that Sharon Saxon murdered her husband, John Smith, at a Perfect Place cat sanctuary on March 18th of 2000.
Do you see Sharon Saxon in the courtroom today?
Yes, I do.
Could you point her out by where she's seated in an article of clothing she's wearing?
Yes, she's seated with defense counsel wearing the yellow blouse and white blazer.
Your Honor, at this time, let the record reflect that this witness has identified the defendant, Sharon Saxon.
As so noted for the record.
Now let's turn and talk about the evidence that you found that led to your conclusion. Now, when were you able to conduct that search of the Saxon property?
I conducted my search on April 13th of 2020.
And is A Perfect Place that property here in Napa County, California?
Yes, it is in Napa County.
And what did your search turn up?
Well, I was able to find John Smith's wedding ring tucked away in one of the storage units, as well as an old dusty jug of sardine oil tucked way back in one of the cabinets in the defendant's home.
Now, I want to turn your attention to a couple of exhibits. Exhibits 6, 11, 9, and 10. Could you let me know when you have 6 in front of you?
Yes, I do.
What is Exhibit 6?
This is a diagram of A Perfect Place property.
How do you know that?
Because I was there as part of my investigation.
And now Exhibit 11. What is Exhibit 11?
This is a photo of John Smith's wedding ring that was found during my search.
How do you know that's a photo of the wedding ring you found?
It was obtained during the search that I conducted at the property.
And now turning your attention to Exhibit 9. What is that?
This is a receipt that was in the case file from 2000 that was recovered from the defendant's home back at that time.
And how do you know that's the receipt that was recovered back in 2000?
I recognize it as having reviewed it during my investigation.
And then finally, turning your attention to Exhibit 10. What is Exhibit 10?
This is a photo of that old jug of sardine oil that was found.
How do you recognize that?
I recognize it because it was found during my search of the property.
And are Exhibits 6, 11, 9, and 10 fair and accurate representations of what they purport to be?
Yes, all of them are.
Your Honor, at this time, the people move Exhibits 6, 11, 9, and 10 into evidence.
Any objection?
Your Honor, we would only object to Exhibit 9, the receipt, on the grounds that it is hearsay.
I'd like to hear the response from the people.
Certainly, Your Honor. First of all, under 801D2B, this is not hearsay as it is an adoptive statement. This witness will testify, if I can make an offer of proof, that the items on the receipt were purchased using a credit card that belonged to A Perfect Place, with the only authorized user being the defendant, Sharon Saxon. Furthermore, this receipt was found at the Saxon property. The defendant never reported that her credit card was stolen or missing. And that same jug of sardine oil that was purchased on that receipt was found in the Saxon property 20 years later. And therefore, the defendant adopted the statements on that receipt.
Anything else from the defense on that?
Yes, Your Honor. This receipt was generated at the Spade hardware store. There is a clerk's name on it. And since the clerk put those items into the system onto the receipt, that is his statement. And thus, since that clerk is not here to be cross-examined today, this is hearsay.
Okay, any response from the people, and then I'll rule.
Yes, Your Honor. Again, I would just reiterate that the defendant has adopted this statement as she never reported the items missing and they were found on her property. In addition, Your Honor, this witness has been tendered as an expert by the court and she relied on this receipt in her investigation. So, and under Rule 703, experts are allowed to rely on hearsay evidence.
Okay, so I'm going to be admitting the unobjected evidence with regard to the objections to number 9. I'm going to be admitting that based upon the representation of that is going to be proven up later, the offer of proof, and in addition, that there'll be evidence that this has been relied upon, and we may later wind up limiting its use. But let's go forward from here.
Certainly, Your Honor. And permission to publish Exhibit 6?
Yes. Any objection? No, yes, let's do so. No,
Now, Investigator Hanson, where specifically on the property did you search? Can you describe it for the jury using this diagram?
Yes. So we searched all of the Cougar cages, which are the smaller blue boxes around the perimeter. We also searched the shed that's in that upper left-hand corner, the storage unit in the bottom right-hand corner, and the defendant's home, which is that big blue box on the right side.
Now, starting with that ring that you mentioned you found on the property, where was that ring found?
Yeah, it was found tucked away in a small container in that storage unit on the bottom right-hand corner.
And Your Honor, permission to publish Exhibit 11?
Yes.
And was there any kind of testing done on this ring?
Yes, there was, and it was found to have saliva on it belonging to the Cougars Malbec and Zinn.
And Your Honor, permission to republish Exhibit 6?
Yes, you may.
Now, turning to that sardine oil, where on the property was the jug of sardine oil found?
Well, so even though there is a feed storage in several sheds, the sardine oil was actually found in the defendant's home. It was pushed way back in one of the cabinets.
And why was this jug of sardine oil significant in your investigation?
Well, first, I thought it was unusual that it was kept in the house rather than one of the storage units. And I also remember coming across a receipt in the 2000 case file, and this receipt had a purchase for sardine oil on it.
And were you able to determine whose credit card was used to purchase the items on the receipt?
Yes, the card that was used is registered to a Perfect Place property, and the only authorized user for that card is the defendant, Sharon Saxon.
And Your Honor, permission to publish Exhibits 9 and 10?
Yes, you may.
So how did that receipt play into your investigation?
Well, I was actually able to scan the barcode on the sardine oil and match it to the sardine oil that is purchased on the receipt. So this sardine oil is the same bottle of sardine oil that was purchased back in 2000.
And was there any kind of testing done on that jug of sardine oil?
Yes, it was tested for fingerprints, and there was a match to Sharon Saxon on the bottle.
And when were the items on this receipt purchased?
They were purchased on March 12th of 2000, just a few days before John Smith went missing.
Thank you, Ms. Spees. Now I want to talk about any potential motives you were able to uncover in this case. Now, when you are investigating a cold case, is it important to try and understand why someone might want the victim dead?
Yes, motive isn't vital to a case, but it can be very helpful for understanding the evidence.
Now, in the course of your investigation, did you learn about anything that might suggest the defendant had a motive to want John Smith killed?
Yes, I reviewed a letter, some text messages, and a power of attorney, and all of these suggested that they were having a lot of marital troubles at the time.
I want to turn your attention to a couple of exhibits again. Exhibits 12, 13, and 8. Starting with 12, will you let me know when you have that in front of you?
Yes, I have it.
What is Exhibit 12?
This is a letter from John Smith sent to Jamie Smith.
And how do you know that's the letter sent from John Smith to Jamie Smith?
I received it as part of my investigation.
Did you receive it? Who did you receive it from?
It was Jamie Smith, who's John and Sharon's son. He's the one that gave it to me.
Now, turning your attention to Exhibit 13, what is that?
These are text messages sent between Sharon Saxon and John Smith. They were pulled off of John Smith's cell phone that had been left in his car.
And how do you know those are the text messages that were pulled off of John Smith's cell phone?
These are something that I reviewed as part of my investigation.
And now finally turning your attention to Exhibit 8. What is Exhibit 8?
This is the power of attorney amendment.
How do you know that?
This is also something I reviewed as part of my investigation.
And are these all fair and accurate representations of those documents?
Yes, all of them are.
Your Honor, at this time, the people move Exhibits 12, 13, and 8 into evidence.
Okay, are there any objections?
Yes, Your Honor, we would object to all three exhibits. Starting with Exhibit 12, the letter, we believe that that is hearsay. Exhibit 13, the text messages, while we recognize that the messages sent from Ms. Sharon Saxon are not hearsay pursuant to the party opponent section, the text messages sent from Mr. John Smith are hearsay. So we would object on those grounds. And then we would also object to Exhibit 8, the power of attorney, as also being hearsay.
Okay, I'd like to hear your response to each of those.
Certainly, Your Honor, and I'll start with Exhibit 12. Once again, this witness has been tendered as an expert, and under 703, she has testified she relied on that in coming to a motive which contributed to her conclusion. Additionally, Your Honor, there are only two statements in here that we would be offering for the truth of the matter asserted if Your Honor does not think this falls under the 703 exception. Those two statements are, "Your mom is acting crazy and I want to get her some help," and the statement, "I will come visit you in April." Those both fall under the exception 8033 for then existing mental, emotional, or physical condition as they go to plan.
Okay, so let's go stick to that one. Any response from the defense before I rule on it?
Your Honor, we would stick on our previous argument that Mr. Smith is not available today. He was not going to be cross-examined, and therefore this is hearsay. And it is being offered for the truth of the matter asserted, as Ms. Hersey pointed out.
Okay, the objections can be overruled, and that one will be admitted. The next matter will be?
Exhibit 13, Your Honor. And as defense counsel has previously stated, some of those text messages are from the defendant, Sharon Saxon herself, and those are not hearsay. The text messages from the victim, John Smith, we are not offering those for the truth of the matter asserted. We are offering those for context along with the other text messages that were sent from the defendant.
Okay, I'm going to be admitting them for that limited purpose, and we're going to be giving a limiting instruction to the jury in that regard.
Certainly, Your Honor.
And there was one more, I believe.
Yes, the last one was Exhibit 8, which is that amendment to the power of attorney. And Your Honor, this falls under 803.15, a statement in document that affect an interest in property. There's only one specific statement in this document that we are trying to offer for the truth of the matter asserted, and that is the statement that the defendant gets control of John Smith's assets in the event of his death or disappearance. That statement is contained in the document, and it purports to establish an effect or interest in property, namely John Smith's $10 million of assets, and that matter stated was relevant to the document's purpose as this amendment was created on March 15th of 2000 to give the defendant control of those assets in the death or disappearance. Specifically, that disappearance term was added. And finally, Your Honor, later dealings with the property are not inconsistent with the truth of the statement, as the defendant did take control of those assets upon Mr. Smith's disappearance back in 2000.
Okay, anything from the anything else from the defense before I rule on this?
Yes, Your Honor, we would stand by our previous argument that these are hearsay documents. This is a legal document signed only by Mr. Smith, and since Mr. Smith is not here today, we believe that this is hearsay since it is being offered for the truth of the matter asserted.
I'm going to overrule the objection and admit it.
And Your Honor, permission to publish Exhibit 12?
Yes.
Now, Investigator Hanson, starting with Exhibit 12, which statements on here stood out to you in your investigation?
Yes, so I noticed that John, who wrote the letter, said that Sharon had been acting strange, that he wanted to get her some help, and also that he did have a plan to visit his son in April.
And when was this letter written?
This was on March 4th of 2000, about 2 weeks before John went missing.
And did you learn anything else about the state of the victim and the defendant's marriage?
Yes, I also learned that John Smith was planning to get a divorce.
Now, turning your attention to Exhibit 13, and Your Honor, permission to publish Exhibit 13?
That's granted.
Now, specifically on these text messages, could you just explain for the jury which text messages are from the defendant, Sharon Saxon, and which ones are from John Smith?
Yes, so these text messages were pulled off of John's cell phone. So his text messages are in green and the defendant's text messages are in gray.
And which specific text messages stood out to you in your investigation?
Yes, so the defendant accuses John of meeting up with the lawyer, with going behind her back, and then she even says, "You want to see crazy, John? I can show you crazy."
And when were those text messages sent?
These were sent on March 6th of 2000, again, just about 2 weeks before John disappeared.
I want to turn your attention to Exhibit 8. And Your Honor, permission to publish Exhibit 8.
Granted.
Is this that will and power of attorney you were mentioning earlier?
Yes, it is.
And what about this document stood out to you in your investigation?
Your Honor, we object on the grounds of the rule of completeness. This is just a small portion of the document that has been admitted to evidence, and we would request that the jury be able to see the whole document in its completeness.
Is that available for the jury to see? Go ahead.
Due to the limitations of the share screen function, it would be difficult to share the document as it is several pages. But since it has been admitted, the jury will have it when they go back to deliberate.
Okay, I think that's going to be sufficient under these circumstances. And for cross-examination, the defense may, of course, use additional portions of the document. You may proceed.
Thank you. Investigator Hanson, what about this document was significant in your investigation?
Well, I noticed an unusual term. It says that Sharon Saxon would get complete control in the event of John's incapacity, which is death, or disappearance.
Now, in your time investigating cold cases, do you look at these kind of documents frequently?
Oh, yes, all the time. I mean, I'm reviewing them in pretty much all of my investigations.
And have you ever seen this term disappearance before?
No, in my 10 years and 200 cases I've investigated, I have never seen the term disappearance in a document like this.
Thank you, Ms. Spies. Now, other than that specific term, was there anything else significant about this document?
Yes, well, it came to my attention that Sharon Saxon obtained the document, but it was never actually verified that John Smith signed it.
So did you do anything to try and confirm if the document was legitimate?
Yes, so I took this document along with the will and the couple's marriage license to a handwriting expert, Eric Knuppel.
And was Mr. Knuppel able to come to a conclusion about whether the document was legitimate or not?
Yes, he concluded that the document had been forged.
How did he come to that conclusion?
Well, so by looking at the signature that was on the document, he compared it to the signature on the marriage license, and they were identical. But now when someone usually signs their name, there's variations in each signature. So it's incredibly unusual for it to be identical, leading him to believe it had been traced.
Well, what do you mean by traced?
As in, like one paper over another, tracing the signature right onto the power of attorney.
Now, does a document like this require any kind of witness or notary to sign it as well?
Yes, it does, and there was one, Evelyn Williams.
So did you speak with Ms. Williams to try and confirm if she had seen this document signed?
Yes, I did, and actually she was spoken to back in 2000 and confirmed signing it, but when I talked to her now again in 2020, she told me that she had felt pressured back in 2000 and that she did not witness the signing and actually has no record of it at all.
And when was this amendment to the power of attorney created?
It was created on March 15th of 2000, just 3 days before John Smith went missing.
Thank you, Investigator Hanson. No further questions at this time, Your Honor.
Okay, the witness is then available for cross-examination.
Yes, Your Honor, just a brief moment to reposition.
Absolutely.
May I proceed? Your Honor?
Yes, you may.
Thank you. Ms. Hanson, during the course of your investigation, you came to know that the will and the power of attorneys had been amended.
That's correct, just 3 days before John disappeared.
And the fact that they had been amended indicated to you that Ms. Saxon murdered her husband.
Yes, because that term disappearance was added in, which is a very unusual term.
But you would agree with me that people sometimes change their wills?
Yes, that's true.
And you cannot say for certain that Mr. Smith did not change his will, can you?
No, but the handwriting expert said that the document had been forged, so I don't believe it was John Smith that changed it.
But it's possible.
Sure, it's possible.
Now, Ms. Hanson, during the course of your investigation, you came to know that Mr. Smith was planning to move to South America.
John Smith, I don't believe so.
You did not come to know that Mr. John Smith was not planning to move to South America.
I knew he traveled to South America and had been contemplating doing stuff down there, but there was no plan for him to actually move to South America.
Ms. Hanson, did you give a report in this case?
Of course.
Your Honor, may I have a moment to confer with my co-counsel?
Yes, you may.
Ms. Hanson, do you have a copy of your report in front of you?
I can if you give me just a moment.
Your Honor, can we assume we're outside the presence of the jury? I could screen share to make it easier on the witness.
We could do that.
I have it in front of me, Your Honor.
Okay. Then,
Okay. Ms. Hanson, can you please look at page 24?
Yes, I'm on page 24.
The third paragraph.
Are you talking about the paragraph from my discussion with the attorney?
Yes.
Okay.
Can you please read along as I read aloud?
Your Honor, I'm going to object to improper impeachment.
okay, may I hear the objection?
Certainly, Your Honor. I don't believe an inconsistent statement has been elicited here. I also don't believe that the defense counsel has verified that this statement was given under oath. I also, Your Honor, there has not been an inconsistent statement as far as I'm concerned.
So, I'll hear from the defense.
Yes, Your Honor. Ms. Tiffany Hanson gave a report in this case in which she stated that Mr. Smith was planning to move to Costa Rica or Venezuela. She has testified here today that she did not learn that, and so I am impeaching her on that inconsistent statement.
Okay, I'll allow that.
Okay. Ms. Hanson, can you read along as I read aloud? At this time, Mr. Smith was planning on trying to move the rescue to Costa Rica or possibly Venezuela. Ms. Hanson, is it your testimony still today that you did not come to know that Mr. Smith was planning to move to South America?
No, as I previously testified to, I was aware that there was some discussion of it, but no definite plan. So as I said here, it was possible, but no definite plan was in place.
Okay. Now, Ms. Hanson, you never looked for Mr. Smith in South America.
Nope, all the evidence pointed right to Sharon Saxon.
But you never found his body?
No, it had been consumed by Cougar, so there was no body to be found.
But you never thought to see if he was alive?
Like I said, all the evidence pointed right to Sharon Saxon.
Okay. Now, Ms. Hanson, during the course of your investigation, you also conducted some forensic analysis.
Yes, I did.
You tested a jug of sardine oil,
That's correct.
and that jug of sardine oil had a fingerprint.
Yes, matching Sharon Saxon.
And that was an important piece of evidence for your investigation.
I mean, not particularly. It just showed that Sharon Saxon had come in contact with the sardine oil.
Even though Miss Saxon works at the rescue, you thought it was odd that there was a fingerprint of hers on it?
No, I didn't necessarily find it odd. It just confirmed that Sharon Saxon had been in contact with that particular bottle of sardine oil. I know there's many other employees there, so it's helpful to know that she came in contact with this specific bottle.
Okay. Now, Ms. Hanson, the Napa Valley Sheriff's Office conducted an initial investigation back in 2000, correct?
Yes, they did.
And they took a blood sample from one of the insides of Cougar cages.
Yes, they found John's blood inside the Cougar cage.
Right. But Mr. Smith worked at the rescue.
Yes, that's true.
He fed the cougars.
Yes, to my knowledge.
And you would agree with me that cougars have teeth.
Of course they do.
Cougars have claws.
Yes, they do.
Cougars can scratch or bite someone.
Yes, that's true.
And blood could have ended up on the inside of a cage from that.
It's possible, but I find it unlikely.
But it is possible.
Yes, possible.
No further questions, Your Honor.
Okay, and the witness is available for redirect.
Now, Investigator Hanson, on cross-examination, you were asked about whether or not you'd found a body for John Smith. Now, when you're investigating a cold case, do you need to find a body to determine someone is dead?
No, you really don't. Someone can die without having found the body, especially in a case such as this, where there's indicators that the body's been disposed of, in this case, consumed by cougars.
Now, you were also asked about the potential of John Smith living in South America. In the course of your investigation, did the evidence lead you to believe John Smith had moved to South America?
No, I had no reason to believe that he'd actually moved down there, especially without a trace. Instead, the evidence was showing that he was murdered at a Perfect Place cat sanctuary.
Thank you. Nothing further for this witness, and may she be excused?
Yes, you may.
Thank you.
Your Honor, the prosecution would call Ms. Rick Wilde to the stand.
Great.
May I proceed?
Yes, you may.
Hello, Ms. Wilde.
Hello.
Would you please introduce yourself and spell your last name for the record?
Of course, my name is Rick Wilde. My last name spelled W-I-L-D-E. Make sure that E is on the end there.
And Ms. Wilde, do you know Sharon Saxon, the defendant in this case?
I do. We've known each other for about 20 years now, and for each and every one of those 20 years, we have not gotten along very well.
Why is that?
Well, I've been involved in the big cat industry for quite some time now, and when Sharon came in a few years after I did, she kind of made it her life's mission to shut down every single business that I owned and operated that worked with big cats.
Did you ever do anything in response to her shutting down your businesses?
Absolutely not. I mean, a lot of people think that I did, and in fact, I'm sitting here in prison right now because a lot of people think that I did something to retaliate, but no, I never did. I tried to work with my cougars, and that's all I did.
Now, I want to shift our focus from Sharon Saxon to your experience with big cats. Now, how long have you been working with cougars?
Most of my life. It started when I was a little kid. I was working in the circus, training different cats, lions, tigers, cougars, you name it. So I would feed them, clean up after them, and just make sure they were well taken care of. But eventually I ended up leaving the circus world.
And what did you do after you left the circus?
So I did a couple of things involving big cats. For a while, I was on a TV program training them. And then after that, I actually owned and operated several small businesses that involved cougars.
So safe to say you've been working with big cats your whole life.
Oh, yes, definitely.
Now, what was your most recent place of employment with big cats?
So the last thing that I did before I ended up here in San Quentin was I actually owned and operated a big cat zoo called It's a Cat's World. It was the place where people could come in and interact with different cats and really kind of gain appreciation for these really beautiful creatures.
And can you describe some of the job duties involved with caring for those cats?
For sure. I mean, taking care of a big cat is a lot like taking care of a house cat, just on a much larger scale. So you have to feed them, clean up after them, give them their medicine. Instead of cleaning up their litter box, you're cleaning up their cage or their pen. Instead of taking them to your local vet, you have to have a specialty vet. And instead of feeding them kibbles and bits, you feed them pieces of meat.
Now, I want to focus on the last thing you said. Instead of kibbles and bits, you feed them meat. Let's discuss a cougar's diet. In your experience, what have you fed your cougar for years?
So I typically try to feed cougars something smaller like chickens, rabbits, things with snappable bones, just so it's easier for them to break it down. But really, cougars will eat almost any meat you put in front of them.
So they could eat something larger than a rabbit?
Oh, for sure. They may have a little bit of difficulty with it. Like if you threw a whole cow in there with them, they may need a little help.
Objection, improper opinion.
I don't think any response?
Yes, Your Honor. Under 701, a witness may testify to anything based on their rationally based opinion. As this witness has just testified, they've owned a cougar sanctuary or a cougar business basically their entire lives. So what they feed them would be well within their rationally based opinion.
Defense response before I...
Your Honor, this witness has not been tendered as an expert, and pursuant to the same federal rule of evidence that opposing counsel just mentioned, in 701, a lay witness cannot make any statements made on any specialized knowledge. Here, the witness should not be testifying regarding cougar behavior or cougar anatomy at all.
Your Honor, may I respond?
Please do.
I've not elicited any testimony about a cougar's behavior or behavioral patterns. I've simply asked her what a cougar eats, and that is well within her rationally based perception as a cougar owner.
I'm going to allow it, but because of the nature of this particular question, that's not similar objections might be appropriate on follow-up.
Yes, Your Honor. Ms. Wilde, do you need me to repeat the question?
Oh, no, I can just finish my answer if that's okay with Your Honor.
Excuse me, Your Honor. This is your court reporter. Can I take a few moments to open a new file?
Yes, you may.
Okay.
Let's take a quick moment, pause.
Thank you.
While we're on a pause, may I ask when the first break will take place to swap out reporters?
Oh, yes, you want to swap reporters? That sounds fine. I know we've run a little long with this first session.
Yes, thank you, Your Honor. Jessica, you're up next.
I'm ready whenever everyone else is.
Just for clarity, I will. Thank you. For clarity, I'll repeat the last question, Your Honor. Ms. Wilde, could something larger than a rabbit, would you feed that to your cougar?
Yeah, no, you can definitely feed cougars larger animals, and I've done it myself. They may need a little help along the way. Like if you threw a cow in there with them, it may take them a little bit longer to eat it. So if you want them to kind of have easier times with it, you can break it down for them. But they will eat just about anything because they are such strong predators.
And Ms. Wilde, do you have the case packet in front of you?
I do.
I'm directing opposing counsel and witnesses' attention to what's been previously marked as Exhibit 1. What is this?
So this is a picture of a cougar and what I would describe as attack mode.
And how do you know that?
I've seen cougars for most of my life. I can recognize a cougar.
And is this a fair and accurate photo of a cougar?
It is when it's kind of getting ready to pounce.
Your Honor, the people would move Exhibit 1 into evidence.
Any objection?
Yes, Your Honor. First, relevance, and additionally, improper opinion to what Ms. Wilde said about attack mode. Again, this witness is testifying regarding cougar behavior and potentially cougar anatomy. This line of questioning is questionable.
Your Honor, may I respond?
Yes.
Pursuant to 401, 402 relevance, this is indeed relevant because it's the people's proposition that a cougar is the murder weapon in this case. It's important for the jury to see the murder weapon and assess its strength, capabilities, and what they think that this cougar could have in fact done to a human. And further, it's not expert testimony because this is based on the experience of Miss Wilde, the experience of her working with cougars her entire life. It's not based on any scientific or factual specialized knowledge.
But aren't you trying to offer this testimony specifically because of her unique experience, and that might provide clarification information for the jury? Isn't that exactly the purpose of qualifying someone as an expert?
Well, we're asking her about her rationally based opinions. We're not asking her for her scientific, technical, or specialized knowledge based on facts that she would not have as an experienced cat owner. So no, we're not. If opposing counsel thinks that we're writing into scientific or technical knowledge, then of course they may object, but we are just asking her for her rationally based opinion as a cougar caretaker.
Okay, one last thing from the defense and then I'll roll.
Your Honor, the opinion that Ms. Wilde is about to be testifying about is based on her years of experience in her specialized field of cougars, with cougars. And therefore, the testimony that they're trying to elicit from her is exactly what an expert witness is.
Okay, I'm gonna overrule the objection on this one, but again, if we start hearing anything that sounds like expert testimony, that will be stricken. Okay, so let's go forward.
Certainly, Your Honor. And permission to publish Exhibit 1.
Certainly.
Ms. Wilde, can you just describe what this cougar is doing? And
Of course. So as you can see, that cougar doesn't look too happy. It's got a little bit of a snarl going on there. As you can also see in that picture, they have sets of 4 pretty sharp teeth. Just
Objection, improper opinion.
Overruled. Go on. You may continue.
Of course, as I was saying, it's got those 4 sets of really sharp teeth right there. They're about the same sharpness as a sharply freshened knife. What you can't see in this picture is that these cougars also have sets of razor sharp claws. What you see when they go to eat prey is they will use...
If the witness could speak a little bit slower for the record.
I'm so sorry. As I was saying, they use those sets of teeth and those claws that when you throw prey in there, they will just go at it.
Thank you, Ms. Hersey. Now, Ms. Wilde, earlier you mentioned that if meat is too big for a cougar, you might help them along the way. Can you explain what you might use to help them?
For sure. I personally have used kind of two methods depending on why a cougar is not eating something. If it's a matter of size, you can use something like a meat grinder to help break it down to make it smaller, like I said earlier. And if it's a matter of them kind of like being a little bit picky, you know how cats can be sometimes, you can do a few drops of like a fish oil, something to entice the cougars.
Now, I want to break that down for the jury a little bit. Let's start with the meat grinder. Do you own a meat grinder at your, well, did you own a meat grinder at your property?
I did, yes.
And did you use it frequently?
Oh, all the time to help them kind of break down those pieces of meat.
Did you find it difficult to operate that grinder by yourself?
No.
Objection, relevance,
Sustained.
motion to strike.
Granted.
And let's move on to the sardine oil. Now, earlier you mentioned you might use it to help the cougar eat. What is sardine oil?
It's exactly what it sounds like. It's oil that's made out of sardines. If it smells basically like that, like a bucket of fish. If you've ever taken one of those like, you know, fish oil health pills, you kind of have an idea of what fish oil smells like.
In your experience, do you use the fish oil often with your cougars?
Yeah, like
Objection, relevance.
Oh, overruled.
Like I said, you use it to kind of help them when cats are a little bit picky. You can also help them use it if there's something that they don't want to take down, like medicine. You just sprinkle a few drops on whatever you're trying to get them to eat, and they will go crazy over it. Like you could even put it on like a railroad tie, and they'd probably try to eat that.
Thank you. No further questions with this witness.
Okay. The witness is available for cross-examination.
May I proceed, Your Honor?
Yes, you may.
Ms. Wilde, let's talk about your experience as a cougar owner.
Of course.
You know that these cougars can be very aggressive, correct?
Oh yeah, no, they can be pretty mean.
Especially when they're hungry.
If you haven't been feeding them regularly, yeah, they can get hangry, as they say.
In fact, they can even harm their own mother if they're hungry enough.
They can.
So if they can harm their own mother, they can also harm a trainer if they're hungry enough, correct?
Sure, it's possible.
Ms. Wilde, let's talk about March 18th, 2000. You were never at the sanctuary the day Mr. Smith disappeared, correct?
No, I've never been at Miss Saxon's sanctuary.
You didn't speak to Mr. Smith on March 18th, 2000?
No, unfortunately not.
In fact, you haven't spoken to Mr. Smith at all that entire month.
No, I don't believe so.
Okay, let's talk about your relationship with Miss
Counsel,
Saxon.
can slow down a bit. Thank you.
Yes, Madam Reporter. Let's talk about your relationship with Miss Saxon.
Okay.
You believe that she is a hypocrite.
I do.
You believe that she is a liar.
Yes, I do.
You believe that Miss Saxon is deplorable.
Look, Counselor, it's not a secret that I don't like Miss Saxon. It really isn't.
Right, and throughout these years, she kept giving you problems.
Yes.
It started when you were training cougars at Big Freed and Joy Show,
Yes.
where she filed a complaint against your show's production.
Objection, hearsay.
Overruled. Let's keep going.
Let me ask the question again, Miss Wilde. She filed a complaint against your show's production, correct?
Yes, like I said, she made it her business to really shut down my businesses. So she did file a complaint.
Then she got down on your throat again when you opened a strip club in 1998.
Yes, she really didn't like that strip club very much.
Then Miss Saxon filed all kinds of grievances with the state of Florida to shut you down.
She did, yes.
Then the lawsuits did not end there. She filed another lawsuit for your roadside attraction.
She did.
Then she sicked law enforcement on your interactive zoo.
She did.
Miss Wilde, let me be very clear. You believe that Miss Saxon killed Mr. Smith, correct?
That is my belief.
Okay, and let me again be very clear. You are currently a prisoner at San Quentin Prison, correct?
It's no secret that I'm in prison. No, I'm currently sitting in a cell.
And you've been convicted of a felony.
Yes, the jury did convict me of trying to have Miss Saxon killed, but that was a wrong conviction.
So that's a yes to my question, that you are convicted.
Yes, sir.
And you've also been convicted of crimes of dishonesty in the past.
Well, I think that's what the law calls them. It was really just me not understanding how taxes work.
But essentially, the law says that those are crimes of dishonesty, correct?
That is what the law has written down, yes.
So that's a yes to my earlier question.
I suppose so, if that's how the law is written.
No further questions, Your Honor.
And you redirect?
Briefly. Now, Ms. Wilde, do you have anything to gain by testifying here today?
Absolutely not, other than a guilty person being found guilty.
And anything that I asked
Objection,
you,
speculative.
Overrule.
and was anything that you said regarding cougars exaggerated in any way?
No, not at all.
Thank you. May this witness be released?
Yes, they may. And so with that being said, I believe that the people have no more witnesses at this point?
Your Honor, at this time, I'm sorry, we would like to read in portions of Jamie Smith's earlier statements.
Okay.
And Your Honor, for clarity's sake for the court, I will be reading the questions and Ms. Spees will be reading the answers.
Okay.
May we proceed?
Yes.
Can you describe your relationship with your father?
We were super close, especially when I was growing up. I was definitely a daddy's kid. My dad was always very kind and generous with me when I was little. I loved him a lot, including all the time we spent together.
What do you mean by had or could have?
Admittedly, it was likely that my father was no longer alive, but there's a small part of me that will always hold on to the hope he is alive and well and living somewhere in South America.
What do you mean by you started to notice more?
My parents were in the business of big cats, mostly cougars. They would rescue abused cougars from all over the world, but as the years went on, they started to argue a lot more.
What do you mean by that?
The money. Breeding and selling big cats is a very lucrative business. My mother grew up very poor and often couldn't afford to eat. She made a promise to herself that she would never be in a situation like that again.
How so?
Strange things started to happen. As I got older, Mom started getting more distant, even from me. My dad worked really hard his entire life, and by the time he died or disappeared, he had acquired quite a lot of assets. My dad loved his children, all of them. He had 2 other children with a previous wife, Valerie. I'm very close with my siblings.
What do you mean by full control?
But in the time where my mom had the authority as his power of attorney, she started moving things around.
Moving things around?
She took assets that were worth more money for herself and left assets that were not worth much at all to my siblings and I.
We're almost done here, Jamie. What do you believe happened, truly believe happened to your father?
I think my mother killed him. I hope not, but it definitely looks like she did.
Isn't it true that your father sometimes used the name Richard Spalding as an alias?
I never heard my father using the name Richard Spalding, and I highly doubt he had an alias.
Thank you. Nothing further, Your Honor.
Okay, and so that's the, I believe that completes then the people's case?
Yes, Your Honor, the people rest.
Okay, and I believe this is the point where we take a break. Is that correct?
Your Honor, may I be heard briefly?
Yes, you may.
We would also like to read a portion of that transcript into the record. Would you like us to do it now, or would you like us to do it during our case in chief?
Could we take our break? I think that probably people would need a break, and then we can do that in your case in chief.
Absolutely, Your Honor.
Okay, because we've gone a long time. And so now how long is the break supposed to be?
It's up to Your Honor, but I think 5 minutes has been typical.
Okay, let's take 5 minutes then.
All right. I have the defense has 49 minutes and 33 seconds remaining.
And the prosecution has 38 minutes and 14 seconds remaining.
Thank you.
Thank you, everybody. Are we about ready to begin? Do we have, I want to make sure also that the evaluators are all ready. And so, because I think a lot of us had to take a quick break. And so, and I just heard a time check, didn't I?
Yes, Your Honor.
So what was that again? Where were they at?
So the defense has 49 minutes and 33 seconds remaining.
Uh-huh.
And the prosecution has 38 minutes and 14 seconds remaining.
Okay. Okay. I hope nobody had plans right for after this. And so I had said 5, we're at, I think, 8 now. Is that right? And so why don't we, I mean, if you'd like, we can start with, just to make sure that any evaluators who haven't gotten back yet, maybe you want to start with reading in the remaining portions of the transcript. And then we can move on to the questioning of the witnesses.
Yes, Your Honor. Directing the court and opposing counsel to page 31 of Mr. Jamie Smith's sworn testimony, starting with cross-examination. Question: you said you believe your father is no longer alive? Answer: that's right, probably not. Question: exactly, probably. Isn't it true that a part of you believes he is living in South America and is alive and well? Answer: I mean, I hope, but it's a very small hope. Question: isn't it true that you actually plan on relocating to South America in order to search for your father? Answer: yes, but. That concludes our reading.
Okay. And so what I should have said was that we're on the record, but thank you, Madam Reporter, for not calling me on it. And so with that being said, I believe that we will turn next to the defense's witnesses. And so the defense, you may call any witnesses. Again, in a trial, the defense is not required to call witnesses. But in our mock trial, we are going to have them.
Yes, Your Honor. At this time, we would like to call Detective Blair Pickus to the stand.
Okay.
Good morning. Please state your name for the record.
You're muted.
Mr. Blair Pickus, that's spelled B-L-A-I-R-P-I-C-K-U-S.
Mr. Pickus, what do you do for a living?
I'm currently a private investigator.
What does that entail?
I'm hired to determine the means and the methods behind someone's disappearance or murder, come to light any new evidence and testimony, and I put it all together to try to come to a conclusion.
And how long have you been a private detective?
I've been a private detective for 4 years now.
How many missing person cases have you investigated as a private detective?
I've done approximately 15 in those 4 years.
Before being a private detective, what did you do for a living?
I worked with the Napa County Sheriff's Department for 30 years. For the first 8 of those, I was a deputy. For the next 11, I was an investigator in the narcotics unit and domestic violence unit. And for the last 11 of those, I was a lead investigator in the homicides division, where I was actually involved in this case back in 2000.
What did you do as an investigator for the Napa County Sheriff's Department?
Very similar to what I do now as a private investigator. I'm brought on to cases to try to come to the conclusion and determine what exactly happened. Most of the time my investigations focus on the means and the methods, and a lot of time motive is derived from that.
What type of training did you have, if any, to become a homicide detective?
Yeah, so I went through the academy, just as every other police officer in the United States does. But then additionally, I have 2,000 hours of homicide investigative training. In that, I was learned how to write these reports and deal with the evidence. I then have a homicide investigation certificate, and that was awarded through mock investigations that we had to conduct independently and come to a conclusion, being overseen by senior investigators at the department, and I actually scored 100% on that certification. And then as the laws and the technology change frequently, we have in-house training every few months to stay up to date and stay sharp on top of our game.
You mentioned handling cold cases. How many cold cases have you worked on as a homicide detective?
Wow, a lot. I'd say at least 150.
Your Honor, at this time, defense tenders Blair Pickus as an expert in homicide investigation.
The witness is available for voir dire.
I have no objection, Your Honor.
Okay, then will be admitted as an expert.
Mr. Pickus, what were you hired to do in this case?
I was hired to determine the details behind Mr. Smith's disappearance, see if I could gather any new evidence and come to any new conclusions on where his whereabouts may be and what happened to him. The means and the methods, like I'm always pretty much doing my investigations.
And when did you start investigating the disappearance of Mr. Smith?
Well, like I said, I was originally part of this case back in 2000, but for the purposes of the private investigator in this new case, I was brought on back in April of this year.
Now, Mr. Pickus, when you review the file again, what did the file include?
The file included some of my original notes, some other investigators' notes, and then some original photographs of Mr. Smith, along with some other witness testimony.
And when this case was reopened, what pieces of evidence did you find?
There were four main things. The first was some DNA evidence. There were then Mr. Smith's belongings. And then we had some new photographs that I discovered of Mr. Smith. The new photographs, the DNA evidence, his belongings in the car, and then a pair of boots.
Okay, you mentioned several things there, Mr. Pickus. Let's break them down. Let's talk about the blood sample first. Where did you find the blood sample exactly?
So the blood samples were actually found in two different areas, but both very minuscule amounts. There was some smears along the feeding slot, and then there were some specks inside the cage. But these, they weren't conclusive to jump to a conclusion back then because of cross-contamination. It also didn't strike us as odd because of the very minuscule amounts.
What was the condition of the blood when you found it?
It was dried up, very dried up. And like I said, both were small amounts. That's why we couldn't conclusively tell back then because the technology, but also again, because it was the very small amounts, it didn't really strike us as odd. It could have been from, a small accident or injury, like a small scratch in the cage.
So right now, were you able to identify whose blood it was?
We were, based on the new technology that's changed in the last 20 years in the claw composition technology, we were able to tell there was a 100% match to human blood and a 90% match to Mr. John Smith.
When you investigated back in 2000, was there blood on Malbec herself?
Not that we saw.
Just so we're clear, did you see Mr. Smith's body inside the cage?
Absolutely not. Would have made my job a whole lot easier.
Now let's talk about the boots. Where did you find the boots back in 2000?
They were out in a shed on the sanctuary by Malbec's cage.
Did the county officers find anything on the boots when this case was reopened?
When they reopened, they did. Originally, they did not. Like I said, that new claw composition technology, they were able to pull off some sardine oil and saliva off of those boots, but this did not lead us anywhere.
Why didn't it lead you to anywhere?
Well, because the boots were obviously stored at the sanctuary for a reason, same as you would wear any protective clothing in any type of dirty jobs. There's a bunch of messy stuff on the sanctuary, including the sardine oil. So, Mr. Smith specifically liked to be a part of the feeding rituals every night. So, he was always up close and personal with these cougars. So because of that, the saliva and the sardine oil was very explainable. Quite honestly, it would have been more odd to not have those substances on the boots.
Okay, you mentioned something about items. Let's talk about those items. You said that there was a car. Where did you find the car?
His car was found at the Teddy Roosevelt Municipal Airport. It's a small airfield right outside of town. And that's where Mr. Smith kept his private planes.
Okay, let's backtrack a little. What, if any, did you find inside the car?
Yes, the 4 things we found in the car were his wallet, his passport, his cell phone, and his keys. And
Did you find
the passport had the defendant's fingerprint on it?
Did you find it odd that the passport had her fingerprints?
No, I mean, they were married. I would expect her fingerprints to be on a lot of his belongings.
Were you able to find any information at the airport that led you to Mr. Smith's whereabouts?
I was. There was a flight log that I was able to discover from the year of 2000. It belonged to one of Mr. Smith's planes. And a flight log has to have all the details of a specific flight. And specifically, 2 of the entries in the flight log struck me as odd, and this is where I began my search.
What do you mean it struck you as odd?
Well, so part of every individual entry for each individual flight, there has to be every single person on board that plane, their name has to be listed, passengers and pilots both included. And on all of the other entries, it was Mr. John Smith. But on 2 of the entries, there was the name Richard Spalding and Richard Spalding only. This led me to believe that Richard Spalding had to have been the only person on the plane, therefore the pilot. And that it led me to believe, because it was Mr. Smith's private plane that he didn't really let anyone use, that Mr. Smith was using the alias Mr. Richard Spalding.
When you
Sorry,
found the name
can the
Richard
witness
Spalding,
repeat a little bit? The last thing I have is, and this led me to believe.
Yes, I can repeat so basically every flight log has to have specific information. And one of those columns of information are specifically the names of every single person on that flight, pilots and passengers included. And on every other entry, there was just one name, Mr. John Smith. On 2 of the lines, 2 of the specific flight entries, there was only one name also, but the name was not John Smith, it was Mr. Richard Spalding. And as it was John Smith's private plane, and he was known not to really let anyone else use it, it led me to believe that Mr. John Smith was using the name Richard Spalding as an alias.
when you found the name
Also,
Richard,
can you speak a little bit slower?
Yes,
For
sorry.
the witness, thank you.
when you found the name,
Wait a minute, pardon me, did you get all of it though?
I'm good, thank you, Judge.
Just want to make sure.
may I proceed, Your Honor?
Yes, you may, sorry.
When you found the name Richard Spalding, what did you do with that information?
So because I did believe that it was in fact John Smith using this name, through my expertise of running these searches on cold cases, I used the alias Richard Spalding with John Smith's date of birth to run a skip trace. And I was able to get a hit off of that skip trace.
What do you mean by hit?
I was able to get a positive hit from that skip trace to a town in South America called Caracas. And so I ran a further surveillance using that information with a 2-mile radius of where I got that first hit. And I was able to get a further confirmatory result off of that.
What do you mean by a confirmatory result?
So off of that search in that 2-mile radius, I was able to, I ran the search in common areas with a lot of foot traffic, banks, convenience stores, supermarkets, stuff like that. And I was able to get a positive search from a small store called Licoteca down in Caracas. And so I pulled the surveillance footage from that, and I saw the man to believe to be Mr. Richard Spalding.
If I showed you a copy of this photograph, would you be able to recognize it?
I would.
Your Honor, referring court and counsel to Defense's Exhibit 16. The witness has a copy of the same. Mr. Pickus, do you have Defense's Exhibit 16 in front of you?
I do.
Do you recognize Defense's Exhibit 16?
Yes, sir.
What is it?
This is the exact photograph that I pulled from that surveillance footage from that store in Caracas called Licoteca that I was speaking about. And in this is Richard Spalding, the John Smith that I believe to be.
When were you able to obtain this photograph?
I obtained this photograph back in May of this year.
Is it a fair and accurate copy of the photograph that you obtained in May?
Very much so.
Your Honor, at this time, the defense moves to admit Defense's Exhibit 16, pre-marked for identification purposes only, as Defense's Exhibit 16.
Are there any objections?
No objection, Your Honor.
Okay, those will be admitted.
Mr. Pickus, what do you see? Your Honor, permission to publish by means of screen sharing.
Yes, you may.
Mr. Pickus, what do you see in the photograph?
I see a man that I believe to be John Smith.
And why do you believe that's Mr. Smith?
I confirmed it via 3 different ways. The first being I had original photographs of Mr. Smith from the case file in 2000. And due to my expertise and training in handling evidence and doing these investigations, I was able to use my knowledge to compare the original photograph from 2000 of Mr. Smith and this photo. And I believe that they are the exact same person based on different features and methods that we have. Secondly, I got a confirmation from his wife, who said that she was most certain that it was him and she could not miss him by his rock star beard for anything that she missed so much. And lastly, I was able to pull the receipt from that exact transaction that's photographed there. And I figured that receipt would have some information, and it did. It had the initials, it was signed RS, which are the initials of Richard Spalding. So based on these 3 things, it confirmed my conclusion that Mr. Smith is alive and well.
After receiving all of the evidence, what is your conclusion on what Mr. Smith did in 2000?
The same that the department's was back in 2000. Given all the new evidence, nothing has really changed. Just the fact that Mr. Smith fled the country on his own will and that he is alive and well in South America.
And based on your expert opinion, do you believe Miss Saxon killed her husband?
Absolutely not. Assuming he's alive, I don't believe that it's possible to be killed and still be alive.
No further questions, Your Honor.
Okay, the witness is available for cross-examination.
Good morning, Mr. Pickus.
Morning.
I want to start by talking about the evidence that suggests that Mr. Smith is dead. Now, as you testified on direct, you used to work for the Napa County Sheriff's Department.
Yes, I did used to work for them.
In fact, you even worked on this case back in 2000.
I did. I was an investigator, part of this case in 2000.
But you weren't the lead detective, right?
I was a lead detective in the homicide division, but on this case specifically, I was not the lead detective.
And back in 2000, there was physical evidence that was collected, right?
There was some evidence back in 2000.
One of those was the defendant's industrial strength meat grinder.
Yes, that was turned over to us.
And that meat grinder was searched for any evidence, right?
As part of our search for all evidence, we do run a full and complete analysis on it.
And all that was found on that meat grinder was bleach, correct?
There were small traces of bleach that we did pull off of that meat grinder.
There was no blood found on that meat grinder?
No.
No skin found on the meat grinder?
No.
Only bleach?
Yes, the only thing that we pulled off was small traces of bleach.
Now, there was also some blood DNA evidence found back in 2000, right?
There was, but there were no conclusions drawn back in 2000.
Well, that blood was found on the cage of Malbec, wasn't it?
Yes, it was found on the cage that Malbec and Zinn both had, but it was on Malbec's portion of the cage.
Right, and there was no blood found on other Cougar cages.
There was not.
And that blood that was found on the cage of Malbec was retested now in 2020.
Yes, the blood samples were retested using the new technology that we have.
And now we know that that blood's a 100% match to human blood.
Yes, we do know that now.
And a 90% match to John Smith.
That is correct.
Now let's talk about a witness who you didn't feel was important enough to talk to in your investigation. Now you're aware that there was an amendment created John Smith's power of attorney a few days before he went missing, right?
I'm sorry, counsel, you cut out a minute for me. I'm not sure if that was just for me or for everyone. Can you repeat that?
Sure. You're aware there was an amendment created to John Smith's will and power of attorney just 3 days before he went missing, right?
Yes, we were aware of that.
And you were aware of this back in 2000.
We were.
And before he disappeared, John Smith was worth about $10 million.
I believe, yes, roughly in that ballpark area.
And this amendment gave the defendant sole control of his assets in his death or disappearance.
Yes, that is correct. There were some, we were also aware there were some issues in 2000 that Mr. Smith and Mrs. Smith were worried about the safety of Mr. Smith given the overseas dealings that he was in. I know there was some, I'm not exactly going to speak on it because I never confirmed the exact details of what was going on down in South America, but I do believe that this amendment, that was the cause behind the amendment 3 days beforehand.
Right. And this will and power of attorney was something that was a little bit controversial back then, right?
I did not feel it was controversial, again, because there were, again, I don't know the exact details, but basically they were doing overseas business down in South America. I believe Mr. Smith would go over there quite frequently. I believe like once a month or so. And because of these dealings, there was a safety concern, as South American countries don't have the best security and there's cartels and stuff like that. And so because he was consistently doing this business on a frequent basis, they built up this super successful sanctuary, and they wanted to make sure that nothing would ever happen to this. So
okay,
because
Mr. Pickus, I'm going to stop you there. Let's talk about how you didn't verify that this document was legitimate. Now there's a witness on this document, right?
Counsel, you asked me about the means behind the words. I feel like it's important for me to finish the testimony on why I didn't look into that.
Certainly, Mr. Pickus, and you had a chance to do that before, and you'll have a chance to do that on redirect. I'm now moving on, and my question is, there was a witness to this document, correct?
There was a witness to this document.
That witness is Evelyn Williams.
Yep, and back in 2000, she confirmed that she signed this document.
Right, but now in 2020, you didn't go and speak with Miss Williams again to confirm her story, did you?
No, we couldn't get a hold of her, and like I said, she did confirm this story back in 2000 to us.
Well, Mr. Pickus, you tried repeatedly to speak with Mr. Rick Wilde, right?
Yeah, but Mr. Rick Wilde, we didn't feel that he was a credible witness at the time, given the issues that she always had, or the defendant always had.
Mr. Pickus, I'm going to stop you there. That's a yes to my question. You tried repeatedly to speak with Mr. Rick Wilde. Rick Wilde.
Purposely did not. He purposely avoided our contact.
But in your investigation, you never spoke with Evelyn Williams.
I did not speak to Evelyn Williams.
Now let's talk about those flight logs that you testified about on direct. Now, you found those flight logs in the Theodore Roosevelt Municipal Airport, correct?
Correct.
And you found those in an unlocked bin.
That is correct.
And you found those now in 2020, not in 2000.
That is correct. We found them when I went back to search the airport in 2020.
Now, for those 20 years, we have no record of who went in and out of that airport, do we?
We do not, but these flights were mostly all confirmed via that log that it did belong to Mr. Smith's plane and model number. Sure,
but for those 20 years, they were in an unlocked bin. We have no record of who could have come in and touched them.
It was a private hangar. The bin itself was unlocked, but it was a private hangar.
But Mr. Pickus, there's no record of who came in and out of that hangar, is there?
There is not.
Now, we also don't know if maybe John Smith ever flew with a passenger, but just didn't put their name down on the flight logs.
Well, seeming that it's, federal law that these flight logs have to be completed with every passenger on board. I do believe, I had no reason to believe that Mr. Smith was not an honest individual in his government dealings. So I do believe that I had no reason to believe that he would ever leave passengers off of it.
Sure, but you never watched Mr. Smith fill out these flight logs?
No, I did not.
You never spoke with Mr. Smith, now or back in 2000 when he was still alive, to ask him how he filled out these flight logs?
I did not. I had no reason to believe that these logs would be false.
Now, Mr. Smith also flew small planes, correct?
He did. He had a few.
And it would take multiple stops to get one of those planes from here to South America.
Depending on which model of plane it was.
Well, none of those other stops are reflected on those flight logs, are they?
I'd have to go look at the specific. I don't have every entry memorized.
Okay, well, now let's talk about some of the inferences that you came to from those flight logs. As you testified on direct, you saw the name Richard Spalding appear twice on the flight logs, right?
That is correct.
So that led you to believe John Smith was using it as an alias.
That led me to believe, and then I confirmed those assumptions.
Right, then you ran a trace for Richard Spalding in Caracas.
That is correct.
You didn't look for Richard Spalding in California.
We searched the sanctuary.
Well, you didn't run a search for a man with the name Richard Spalding anywhere in California, did you?
Well, these two flights were specifically to Caracas, and Caracas was Mr. Smith's favorite place. So that's why I started my search in Caracas. And as soon as I got the hit that showed a photograph of Mr. Smith, I didn't need to search anymore.
But Mr. Pickus, that's a note. You never searched for Richard Spalding in California.
No, because I found Richard Spalding, John Smith, in Caracas.
Well, you also never searched for Richard Spalding anywhere else in South America, did you?
No, counsel, but again, it wouldn't make sense to search after I found him already.
I understand, but that's a no to my question, right? You never looked for another Richard Spalding in South America.
That would waste a lot of resources and it would run up my bill. And my job is to get my job done as efficiently, conclusively as possible and not run up high fees on my clients.
Okay, well, let's talk a little more about this Richard Spalding that you found. Now, you found this man in a convenience store in South America, right?
That is correct. A store called Licoteca down in Caracas.
And one of the reasons you believe it's him, as you testified on direct, is because he signed a receipt RS.
That is one of the three reasons.
Now, you'd agree with me, RS could stand for Ron Smith.
I would agree with that.
It could stand for Robert Sanchez.
As long as that name started with the initials RS, I would agree.
Right, it could be any other number of names with the initials RS.
That is exactly correct, and that's why I didn't rely just on the receipt. That's why I confirmed via photograph two separate ways.
Right, you also took that photograph to Sharon Saxon, correct?
I did take that to Sharon Saxon, yes.
And she told you she believes it's John Smith.
She not that she believes, but she was most certain that it was him. She couldn't miss his specific rock star beard that always stood out.
Okay, well, you never took that photograph to John Smith's son, Jamie, did you?
No, he wasn't really part. I know he's overseas right now. And based on my expertise and training for the 30 years of the department, I'm really experienced in handling evidence. And part of my training was how to identify specific evidence. And so, like I said, I compared that original photograph from 2000 to 2020, and they were an exact match for Mr. John Smith.
But Mr. Pickus, you also never took that photograph to either of John's other two children to confirm if they believed it was him.
Again, counsel, in my industry, there's a ton. You could go on and on and on confirming things a million times, but at a certain point in time, it just gets repetitive and you're wasting resources. So, once
you would agree with me, Mr. Pickus, in your years of experience, you want to be thorough in an investigation, correct?
Yeah, I believe I do very thorough investigations.
Yet the only person other than you who confirmed they believe this photograph is John Smith is the defendant.
Counsel, again, but you're alluding to the point that just the defendant herself did it. There's also other methods, such as the receipt that I used, So
right, Mr. Pickus. So my question is, the only person besides you and your method using the receipt, the only person who confirmed it's John Smith is the defendant.
And myself, yes.
Okay. Now let's talk about what you did after you got this photograph. Now, you never tried to contact this man in Caracas, Venezuela, did you?
No, I mean, John Smith fled the country. I don't know the exact reasons. I was not hired to find the reasons. I was hired to determine if he's alive and well. And once I confirmed that he's alive and well, my job was done on that portion. I respect the man's wishes if he fled the country for whatever reasons.
So that's a no. You never tried to contact this man in South America.
That would have taken a lot of resources with a crew of its team to fly there to find him. So no, we did not.
Oh, Mr. Pickus, let's talk about what else you didn't do with this photograph. Now, you testified you got it in May, correct?
Yes, it may.
And then shortly thereafter, you took it to the defendant to confirm it was John Smith.
Yes.
Now, at this point, you have this photograph you believe proves her innocence and proves that John Smith is alive, right?
That's not a total characters. That's a little bit of mischaracterization. I was hired to determine the whereabouts of John Smith, not the innocence of Miss Sharon Saxon. So.
Okay, well, you believe this photograph confirms he's alive.
Yes, I do.
And at this point, the Department of Justice had already searched the Saxon property, right?
Yes, yeah, they have multiple times, I believe.
Yet you didn't take this photograph to the Department of Justice or the Napa County Sheriff's Office.
They may have asked for it in discovery. I'm not exactly sure, but I'm a private investigator on behalf of a private client, not the state or the government. If they ask for it,
you still have connections in the Napa County Sheriff's Department, right?
Sorry, counsel, what was that?
You used to work for the Napa County Sheriff's Department, so you still know people who work there, right?
Yeah, I mean, I worked there for 30 years, so I know some people still there.
And you never took them this photograph, did you?
Again, counsel, they're an adverse party at this point in time. I think they actually know. I believe it was in discovery. I believe that the department does have access to this photo, actually.
Okay, well, Mr. Pickus, at the point you got that photograph, you didn't take it to your friends in the department, did you?
That would be a conflict of interest, to be honest with you. I keep friends and business separate. I had no reason to go running to the Department of Justice.
All right, Mr. Pickus, no further questions.
Okay, the witness is available for redirect.
Yes, Your Honor, may I proceed?
Yes, you may.
Mr. Pickus, after reviewing all of the evidence, what is your conclusion and what happened to Mr. Smith?
The exact same that the department's was back in 2000. No new substantial evidence has come to light that would show anything otherwise. My conclusion is still that Mr. Smith fled the country on his own will and that he is alive and well, at least as of May of this year.
And what pieces of evidence are most important to you in making that expert opinion?
The flight log that originally showed that he was going, he went to Caracas under the name Richard Spalding, and then the positive search using Richard Spalding and John Smith's date of birth. The additional confirmation hit that has the photograph evidence of Mr. Smith. And like I said, the three ways that I confirm that via the original photograph in the file in 2000, confirming it with his wife, and then lastly, confirming it with that exact, the record of the transaction at the store at that time that confirmed that that was in fact Mr. Richard Spalding.
And based on your expert opinion, did Miss Saxon kill her husband?
I do not believe so. Like I said, he's still alive and well, at least as of May.
Your Honor, no further questions. This witness may be excused.
Yes, the witness may be excused.
Your Honor, may we call our next witness?
Yes, you may.
At this time, defense calls Sharon Saxon. May I proceed, Your Honor?
Yes, you may.
Good morning. Can you please introduce yourself to us?
Yes, my name is Sharon Saxon, last name Saxon.
And what do you do for a living, Miss Saxon?
Well, I am the now owner of A Perfect Place, which is a wildlife rescue and sanctuary for big cats.
How long have you owned the sanctuary?
About 28 years now.
Did you start it on your own?
No, I actually started it with my then husband, John Smith.
Now, Miss Saxon, we've heard a lot today about you and Mr. Smith, but can you please tell us when you first met?
Well, we met back in 1985.
And when did you marry?
We married a little bit later in 1992.
And when did you start to get in the business of getting big cats?
Actually, right away. So for my wedding gift, I received a baby cougar from John, and we just fell in love with the little guy, and we decided to go and get another one. So on our honeymoon, we went to Montana to the guy that John had originally gotten the baby cougar from, but we saw that he was operating a fur farm, and it just broke my heart. So we decided right then and there that we were going to go and buy all those cougars, all 50 of them, and start our farm.
Wow, that's a lot of cougars. What were you going to do with all of those animals?
Well, that's when we got the idea for the wildlife rescue. John would fly all over and rescue these mistreated cats, and we would have them at the sanctuary.
How many cougars did you end up having at the sanctuary?
At our largest, we had over 200, but now we have about 58.
Is all you do at the sanctuary house the cats?
No, so big cats are expensive to keep. So we decided to come up with this awesome way to raise a little bit of extra money, which was to create a wine brand, which is our personal wine brand at the sanctuary. And we would actually name the cougars after wine so that people could come, drink wine, but mostly learn about the cougars and their mistreatment.
Okay. Ms. Saxon, I briefly want to discuss Mr. Rick Wilde. Did you see her testify today?
I did see her testify, yes.
Do you know her personally?
Yes. Unfortunately, we have a bit of a nasty history.
Can you explain what you mean by a nasty history?
Well, you see, Rick and I were in the same business as in we owned cats, but we saw the business very differently. I filed all sorts of grievances with the government to shut down what he called businesses, but I also filed personal lawsuits against him and her, and she actually threatened to hire someone to kill me.
Okay. Now, Ms. Saxon, I want to switch gears and discuss the disappearance of Mr. Smith. In the months leading up to his disappearance, did you notice anything different about him?
Unfortunately, yes. He started forgetting things. There was just apparent mental decline going on. There was this terrible habit of hoarding that he took up, and he was collecting all this junk on the property. He would go dumpster diving, and there was this one incident where he actually got stuck in a dumpster and had no clue where he was, and I found him crying, and he had no clue where he was, and it was hard for us and our marriage at that point.
Did Mr. Smith ever see a doctor for these forgetful tendencies?
Yes, I made an appointment for him, and it wasn't until after he disappeared that I learned that he actually did go.
Your Honor.
Was that?
Objection, hearsay. Regarding the doctor and his diagnosis.
Your Honor, I do not believe that Ms. Saxon mentioned anything about a diagnosis.
Overruled.
Thank you, Your Honor. Now, Ms. Saxon, when was the last time that you saw Mr. Smith?
Well, it was the night before he left. He told me that he was going to go feed the cougars and that he had to get up early the next day to go look at a plane in Mexico City. So I just went to bed.
Now, did Mr. Smith fly to South America often?
Yes, he would fly down there all the time because we were in the business of rescuing these cats. At one point, he was flying there once a week every month. And so he started to do so under the radar, though, because he had lost his pilot's license.
Now, did you have any safety concerns because of that?
Yes, he would fly down there. Well, yes, I did, because at the time we knew that people were disappearing, and it was...
Okay. And speculation. Objection, hearsay, and speculation to the fact that they knew people were disappearing down there.
Okay, I'd like to hear defense.
Yes, Your Honor. This witness is just testifying to her own personal knowledge of what her and her husband had discussed and their safety concerns together as a couple.
May I respond?
Yes, please do.
Exactly. She's eliciting testimony about what they discussed, which is in fact an out-of-court statement being offered for the truth, which is people were disappearing in South America.
Objection sustained.
Now, Ms. Saxon, you testified today that you worked at the sanctuary and that Mr. Smith worked there with you. If I showed you a picture of Mr. Smith at the rescue, would you recognize it?
Yes, I would.
Directing the court and opposing counsel to what's been pre-marked for identification purposes only as States 14. Ms. Saxon, do you have States 14 in front of you?
Yes, I do.
Do you recognize that photo?
Yes, I do.
How do you recognize it?
Well, it's a picture of my John at the sanctuary with one of our Cougars, Malbec.
And is that a fair and accurate representation of Malbec the Cougar and your husband John at the sanctuary?
Yes, it is.
Your Honor, at this time, defense moves into evidence what has been pre-marked for identification purposes only as States 14 into evidence as Defense 14.
Any objection?
No, Your Honor.
Okay, that'll be admitted then.
Permission to publish to the jury via screen share?
That's granted.
Now, Ms. Saxon, are you familiar with a Detective Blair Pickus?
Yes, I am.
Do you remember seeing any pictures from his investigation?
Yes, I remember when my husband went missing, we found pictures of John, and he had some of those.
Would you recognize that picture if I showed it to you?
Yes, I would.
Your Honor, at this time, I am going to be showing the witness what has been entered into evidence as Defenses 16 via the screen share function.
Yes.
Ms. Saxon, can you see this photo?
Yes, I can.
Do you recognize it?
Yes, I do.
How do you recognize it?
Well, it's a picture that Detective Pickus showed me of my husband, John.
And how sure are you that that is Mr. Smith?
100% certain. I would recognize that rock star beard anywhere.
Finally, Ms. Saxon, I want to discuss some of the allegations that have been made against you today. We heard from the state that they believe that you put sardine oil on your husband. Did you put sardine oil on Mr. Smith?
No, I did not.
Can you explain why there might be sardine oil at the rescue?
Well, we use the sardine oil as a digestive aid for the cougars. It's mixed into their food, it helps them digest, and it also gets them excited to eat. But, I mean, it's all over the place.
Now, we also heard the state testify today that they believe that you put your husband through a meat grinder. Did you put Mr. Smith in a meat grinder?
No, absolutely not.
We heard testimony today that they believe that you forged signatures on the will and the power of attorney. Can you tell us who signed those documents?
John signed those documents.
Speculation.
Stop for a moment. I'm sorry, I didn't mean to cut off your objection. If you want to do that, and then we can take a short break.
Okay.
Your Honor, I will rephrase my question.
Okay, so let's take our can we take the short break now and for the changeover? And I just want to note that this is our last witness, and so we're going to take a short break. How long? Okay.
On the record.
Okay, we're ready. Okay, let's go back on the record. And you were going, ma'am, you were going to restate your question.
Yes. Ms. Saxon, did you forge the signatures on the will and the power of attorney?
No, I did not.
Finally, Ms. Saxon, did you kill Mr. Smith?
No, I loved my husband, and the day he left, I was heartbroken, but I did not kill my husband.
No further questions at this time, Your Honor.
Okay, the witness is now available for cross-examination.
Yes, Your Honor, thank you. Hello, Ms. Saxon.
Hello.
Now, I want to begin by discussing some of the marital troubles that you and your husband were having before he disappeared. Now, your husband used to breed cougars, right?
Yes, unfortunately he did. It brought in money to the sanctuary, so like I said, the big cats are expensive.
Right, and you were avidly against breeding, correct?
I was, yes, but it's hard to, take care of the cats and also pay for the sanctuary.
You were an anti-breeding activist, correct?
I guess I could classify myself as anti-breeding.
You classified it as something that went against everything you stood for.
Yes, that's why I tried to raise and take care of my cougars humanely.
Right. And you asked your husband to stop breeding, didn't you?
I did, yes, but he wanted to make sure the financials were in order so that the sanctuary could continue to take in these mistreated cats.
Right, he refused to stop breeding.
Yes, unfortunately.
Which is why, during a conversation you were having about breeding, you told him you would shoot him.
It was a conversation and it was brought up as a joke, but I never would hurt him. I was just upset at the time because I really didn't want us to have to continue to breed these cats.
And after that, what you classified as a joke, your husband filed a restraining order against you.
Well, at the time, I was getting rid of the stuff he was hoarding on our property, so he was more upset about that, and he needed physical reason.
Ms. Saxon, I'm sorry. My question's much simpler. I'm not asking why he filed a restraining order. I'm asking, did he in fact file a restraining order against you? Yes or no?
It was alleged, yes.
And after that alleged restraining order was filed, that was in 1999, correct?
I believe so, but I don't think it was ever granted.
And after that restraining order was filed, your husband disappeared a few months later in March of 2000, specifically March 18th.
Yes, that's when he left.
Now, after your husband disappeared, you gained sole control of a perfect place.
Yes, so through the disappearance clause, which we added because we were afraid of the disappearances happening in Mexico City, he disappeared and I got control of his assets.
And after you gained control of his assets, you were finally able to stop the breeding that you hated, correct?
Well, I actually didn't. They weren't dispersed until after his will when he was declared dead in 2005, so I didn't have those assets right away.
But ma'am, you did in fact stop breeding after your husband disappeared.
Yes, immediately after, so I wasn't waiting on his assets.
Right, immediately after he disappeared, you stopped breeding.
Yeah.
Now, I want to talk about another marital trouble that you were having with your husband. It occurred on March 6th of 2000. Do you know what I'm talking about?
I'm assuming the text messages.
Yes, permission for my co-counsel to republish what's already been admitted as Exhibit 13, Your Honor.
Yes.
Now, I want to draw your attention to one message in particular. You told your husband, "You want to see crazy, John? I can show you crazy."
Yes, that's what it says.
Thank you, Ms. Kersey. And that happened 12 days before your husband disappeared.
Yes, that's when I learned of him having an affair and going to the divorce attorney, and I was, at the time, I was heartbroken. Okay.
Your Honor, motion to strike for speculation for an affair. Your Honor, I'll just proceed. It's fine.
I'm going to grant it. And so, go ahead. I just
Your
want to know
Honor.
the argument.
I'm sorry?
I was just trying to see if either side was trying to argue it before I granted it.
Yes, Your Honor. And after you learned, I'm sorry, let me reorient myself. And now I want to discuss the last day that you saw John alive. Or he left early in the morning for Mexico City, correct?
Yes, at least I think he went to Mexico City. I don't know for certain.
And you also were seen out early in the morning on March 18th, right?
Objection, hearsay.
Response?
Yes, Your Honor. This is her own statement that, or, Your Honor, one moment to confer with co-counsel.
Yes, I'll allow that.
I'll rephrase.
Okay.
Ms. Saxon, you were out at 3 in the morning to go get milk, correct?
Yes, we had just taken on a whole bunch of baby cougars and they woke up crying. And if you ever raised a baby puppy or a baby, a human child, you need to go get them milk when they're crying.
Right. And so to go get milk, you went to a store that's near your home, correct?
Yes, we were all out.
And you returned home without milk for those baby cougars who you described were screaming.
Yes, because unfortunately the store I went to was closed.
And you did not go to another store that night, did you?
I don't believe so, no. It was really late.
And then later that same day, you called the police and told them your husband was missing, right?
Yes, I was worried for him and called the police.
And the police checked the airport where he was supposed to be leaving from, correct?
Yes.
And they found his car still at the airport.
What was that, counsel? I'm sorry.
They found his car still at the airport, correct?
Yes.
And inside of that vehicle was a passport.
Correct, yes.
And his cell phone.
Yes.
And his wallet still inside.
I believe that's what they found, yes.
Now, I also want to discuss the $10 million you gained after your husband disappeared. So your husband had a will and a power of attorney created in November of 1999, correct?
Yes.
And then that was altered.
Yes, he amended it to include the disappearance clause.
And after he allegedly amended it, that was done on March 15th of 2000, correct?
Yes.
And it was your idea to include the disappearance clause. Yes or no?
Yes. We were worried about the disappearances going on in South America and knew it was dangerous. And also, given his mental state, we were worried.
And after you included that clause, he disappeared 3 days later.
Yes, after he amended it, he left.
Now let's discuss that timeline. Your husband owned multiple planes, right?
Yes.
He took frequent trips to South America.
Yes, and most recently, most under the radar.
And you were married for approximately 8 years at that point?
Sounds about right, yeah.
But he didn't leave you sole control of his estate upon his disappearance until 3 days before he disappeared.
Yes.
And once he did disappear, not only were you able to stop breeding, but you gained $10 million in assets.
I actually gave $2 million of that to the children and kept the rest of the sanctuary. I'm sorry, counsel, could you rephrase, or not rephrase, repeat?
Ms. Saxon, I didn't ask how much you gave away. I asked whether or not you received $10 million in assets.
I received $10 million, and yes.
Thank you. No further questions.
Okay. The witness is available for redirect.
Yes, Your Honor, briefly. May I proceed?
Yes.
Ms. Saxon, do you have any reasons why you would want to hurt your husband?
No. I loved John. I loved what we did together at the sanctuary, taking care of these cats. I wish he was still here with me, raising these cats.
Have you ever harmed Mr. Smith?
No.
Ms. Saxon, did you kill Mr. Smith?
No. I'm heartbroken he's gone. in South America, but I did not kill my husband.
No further questions, Your Honor. May this witness be excused to defense's counsel table?
Yes.
Your Honor, at this time, defense rests its case.
Okay, so now both the people and the defense have presented their cases. We're going to be going to closing arguments, but I believe that at this point we're going to be taking a short break as the parties prepare. Is that that's correct, right? Typically,
That's fine, Your Honor. We can do that, and we'll provide a time check when you get back. Do you want to say 5 minutes again?
at the most, yeah. I mean, I just thought everybody might need a moment to.
Or however long you want, Your Honor.
5 minutes is the most I would want. Okay, let's take 5.
Okay.
Thank you, Your Honor.
Okay.
Absolutely. So the defense has 23 minutes and 59 seconds remaining. And would you still like that 5 minute audible time check or warning, as well as a 1 minute? You're muted.
Yes, Mr. Bailey, I appreciate it.
Okay, will do.
Prosecution?
And I would love a time check too if you're available for prosecution.
Yes, prosecution has 13 minutes and 59 seconds left total for their time. Would you still like the 5 minutes you requested earlier?
Can you give me a 3 minute instead of 5?
This is for, you're reserving for the rebuttal or
Yes,
the
please.
warning?
Yeah, for rebuttal that you could just, you can let me know when I have 3 minutes left. Thank you.
Then perfect. So then you'll have the 10 minutes, 59 seconds.
I'm gonna just wait a moment to make sure that everybody's back. We're just about ready to proceed. And so I just want to make sure that, okay, we've got an evaluator here.
Your Honor, we're swapping out reporters again, so Yolanda will now be the reporter.
Sounds good. Okay, so we're going to be swapping reporters at this point, and then after that, in a moment, we'll be let's restart. Going on back on the record officially. Are the parties ready to provide their closings?
Yes, Your Honor, I'm ready.
Your Honor, defense is ready as well.
Okay. And I believe was there some talk about reserving time, or?
Yes, Your Honor, I've spoken with the bailiff and I am requesting to reserve 3 minutes for rebuttal.
Okay. So you may proceed with your closing.
The defendant ended her husband's life using the one thing that had brought them together, their cougars. On March 18th of 2000, as the cougars Malbec and Zid stood anxiously waiting by, the defendant coaxed her husband, the victim John Smith, to their cage. What John Smith didn't know was that earlier in the day, the defendant had put a small amount of sardine oil on his clothing. She'd even put a little bit on his body. And as she got him to the cougar cage, she told him that the cougars had been fed earlier in the day. when in fact she had been starving them to get them to peak aggressiveness. And as they got to the cage, the defendant got the victim inside that cougar cage and closed and locked the door behind him. Then she pulled that removable divider separating the cougars from their prey. And when Malbec and Zinn smelled that sardine oil on the victim, they pounced, immediately tearing him to shreds and killing him in just moments. And then after she was done, the defendant gathered up what was left of her husband, fed it through her industrial strength meat grinder, and then fed his remains to the rest of their cougars. Just like she had promised, she showed him crazy. And in a final act to cover up what she'd done, she poured the 4 gallons of bleach she just purchased down that meat grinder to cover her tracks. And she removed the victim's wedding ring as a trophy of what she'd done and kept it tucked away in a storage unit for 20 years. As the defendant's husband had to disappear, but his money had to stay. Now, for her acts, we have charged the defendant with first-degree murder and murder for financial gain. And as the prosecution, we do bear the burden to prove these beyond a reasonable doubt. And we have met that burden today. Now, to understand how this marriage turned into murder, we have to go back to March of 2000, when things in their marriage fell apart. And when the months leading up to March of 2000, John Smith had filed for a restraining order against the defendant after she had threatened to shoot him for continuing to breed. And for months, the couple was fighting over whether to breed the cougars, fighting over control of the sanctuary, fighting over money. Fighting so much that John Smith got fed up and he planned to divorce the defendant. Then on March 6th, the defendant caught wind of that, and the couple fought over those text messages. After John Smith let the defendant know that he'd be home late, she replied, "Don't wait, don't bother coming home, John." And this fight continued. So the defendant confronted him for going to talk to their lawyer about getting a divorce. And then the defendant said those fateful words, "You want to see crazy, John? I can show you crazy." And at this moment, there's no going back in this marriage. No matter what the couple had shared, this marriage is over. And the defendant knew she had to put her plan into motion. She had to make her husband disappear, but she needed his money to stay. So on March 12th, the defendant goes out and buys her murder kit. That's just 6 days after this text message fight. The perfect combination of items to commit a murder by Cougar. Sardine oil, black leather gloves, a heavy-duty tarp, and 4 gallons of bleach. She even bought a magazine and a snack to keep herself entertained while the Cougars tore her husband apart. And we know the defendant used these items in the murder because that same jug of sardine oil found 20 years later in the defendant's home was purchased on that receipt from March 12th of 2000. That sardine oil that was kept in the defendant's home so she could use it on John Smith's clothes and his person. We also know she used the 4 gallons of bleach that she bought. She used that bleach to douse her meat grinder in it to try and clean up any evidence of blood or skin or anything else that could link her to John Smith's death. Now, despite the defendant's best efforts to cover it up, she left more evidence behind showing what she'd done. She had everything she needed to make her husband disappear, but then she took the steps to make sure his money would stay. Because on March 15th, just 3 days later, the defendant forged and created that amendment to the will and power of attorney. That amendment that gave her sole control in the event of his death or disappearance. And we know that document was forged. We know that the signatures are traced, that the defendant took their marriage license and traced those signatures onto this new will and power of attorney. The expert handwriting analyst, Eric Knuppel, did analysis on this document and concluded they were too similar to be authentic. Then there's that term, death or disappearance. That term that gave the defendant full control of John Smith's $10 million of assets. That term that investigator Tiffany Hanson told you is highly unusual, and she's never seen it before in her 10 years of investigating cold cases. And the defendant needed it to say disappearance because her plan was to kill her husband and make it look like he disappeared. And if she killed him, covered it up like she planned, it could take years before she got control of that money. But with this term, she got that immediately. You heard that she immediately started moving money around, taking control of those assets and leaving only the less valuable ones to all of John's children. And it was only 3 days after this document was created that John Smith was reported missing because the defendant killed him. She also left behind some crucial pieces of physical evidence linking her to the crime. First, there's that blood DNA. That blood that's a 100% match to human blood and a 90% match to John Smith. And that blood was found on the inside of the cage of Malbec and Zinn. These same cougars that the defendant used to kill the victim. Now, the only way that blood gets on the inside of the cage is from the cougars tearing him apart while he's in the cage. It doesn't get there from him nicking his finger or getting a little scrape. That only gets there from those cougars. And then there's the victim's wedding ring. This trophy the defendant kept tucked back away for 20 years as a trophy from what she'd done. And that wedding ring had the saliva of Malbec and Zinn, members of the jury, the same cougars whose cage the blood was found in, the same cougars who the defendant used to kill the victim. And the defense wants to talk about all the reasons John Smith might have to fly down to Costa Rica to start his new life. But we know that's not what happened. Let's talk about all his reasons to stay. First is that $10 million, money John Smith spent his life accumulating. We're not talking about $10,000 or even $100,000. This is $10 million. The defense wants you to believe he just decided to leave it behind to the woman he was planning on divorcing, the woman who filed a restraining order against him. No. But his money is not the only reason John Smith had to stay. Because as much as a perfect place was Sharon Saxon's life's work, it was the victims as well. He loved those cougars. He loved caring for them. But he loved his children and his family more. You heard about that close relationship he had with all his children, and especially Jamie Smith. And 2 weeks before his disappearance, before the defendant killed him and tried to cover it up, John Smith told his son, "I will come visit you in April." Because he had plans to do that. He didn't plan on picking his life up and disappearing. And finally, John Smith was going to get his new start, but it was going to be here in the United States. He was planning on divorcing Sharon Saxon, starting over, away from the fights. But he never got that chance because the defendant murdered him before he had that opportunity. We have proven the elements of this crime beyond a reasonable doubt, members of the jury. We have proven that the defendant set out a plan for days, weeks leading up to his murder to kill John Smith using her Cougars. We have proven that she committed an act when she threw John Smith in that Cougar cage and left him to be torn apart. We have proven that she did all of this for financial gain, because the defendant needed her husband to disappear, but she needed his money to stay. Now, in your jury instructions, you'll see the definition of reasonable doubt. Reasonable doubt is not a doubt based upon speculation. It's a doubt based upon reason and common sense. And the defense has brought you nothing but speculation today, because reason and common sense in this case and the facts and the evidence point to only one conclusion. And that conclusion is that the defendant murdered her husband using their Cougars. Now, even though it's taken 20 years, John Smith can still get justice. Find the only verdict that brings justice to John Smith and find the defendant guilty.
Okay. Closing from the defense?
Yes, Your Honor, may I have a moment?
Yes.
To reposition. May I proceed?
Yes, you may.
May it please the court, opposing counsel, members of the jury. Conclusions based on assumptions. Throughout this entire trial, the state kept concluding that Ms. Saxon committed first-degree murder and that she killed her husband for his money. But members of the jury, there is no evidence to make any of those conclusions. In fact, the only right conclusion that the prosecution made is that Mr. Smith disappeared. The prosecution's version of how he disappeared or where he disappeared to are based on mere assumptions that they have made. But unreasonable and unsupported assumptions are not enough. The prosecution painted you their perception of what could have happened or what might have happened. But members of the jury, that is not their burden. In fact, it's not even their burden to show you what probably happened. Their burden is to show you what did happen and to convince you of it beyond any reasonable doubt. That high burden is a burden that they have utterly failed to meet. In order to prove that Ms. Saxon committed first-degree murder, the state was required to prove to you three things beyond a reasonable doubt. First, they needed to prove to you that Ms. Saxon committed an act that caused the death of Mr. Smith. Second, that her actions were premeditated. And third, that she had the mental state to kill. In trying to prove these elements, the prosecution called only two witnesses. They called Miss Wilde, a prisoner who currently lives in San Quentin prison, who has committed several felonies in the past. Miss Wilde did not testify to you today because she wants the truth to come out. No, she testified because she wants revenge against Miss Saxon, a former business competitor who tried to get several of her businesses shut down. She told you that Miss Saxon caused her strip club to get shut down in 1998, and then the roadside attraction in 2005, and then the zoo, and then there were several other grievances. It is clear that you cannot trust this testimony because it is motivated by anger. But even so, let's talk about what she said. Miss Wilde speculated that Mr. Smith that Miss Saxon was somehow involved in an alleged murder. But to be clear, this is pure speculation because she wasn't at the sanctuary that day. She never spoke or saw Mr. Smith the day he disappeared. She even told you that she has not spoken to Mr. Smith for a very long time. If she didn't see it, and if she didn't hear it, where is she getting all this information from? She is making it up. You heard her yourself, and she told you that she was convicted for hiring someone to murder Miss Saxon. This convict is making up all these theories because she hates Miss Saxon and she wants to get her revenge. And you should not give this testimony an ounce of credibility. Now we're left with the other witness. The state called Miss Tiffany Hanson, who also testified about her investigation. Again, this witness made some pretty strong conclusions that relied on unsupported and unreliable assumptions. Now let's talk about each one of them. First, Miss Hanson said that Mr. Smith's blood DNA was found inside the cages. Members of the jury, let me ask you this. So what? Mr. Smith had been inside these cages, training these wild cougars for many years. Accidents and injuries are inevitable when you're handling big cats. In fact, this is corroborated by Miss Wilde, the state's own witness, who told you that these cougars have the tendency to act wildly, that they could even harm their own trainers if they wanted to. Mr. Pickus told you that the blood was already dry when they investigated. And he told you that there is absolutely no way to conclusively say how long the blood had been there. The blood on the cages do not mean anything, except that Mr. Smith could have been harmed by the wild animal in the past. Miss Hanson then talked about fingerprints on the passports as well. And it was left inside the car. Now, let me ask you this. So what? We are talking about a couple who have been together for many years, and couples touch each other's belongings. The investigators also found one of Mr. Smith's boots inside the cages, and they told you that it had sardine oil on it and that there was Malbec saliva on it. And you probably know my next question. So what? We are talking about an animal sanctuary here, where food goes all over the place, where animals drool. As you've already heard, sardine oil is used like crack to cougars because it makes their food more appetizing. It makes them digest food better. And people wear boots inside the sanctuary and not the ones we're wearing right now, like regular day-to-day shoes, because people step on things like cougar saliva and sardine oil inside a sanctuary. Mr. Smith clearly stepped on those things the day he disappeared or days prior. They also talked about the meat grinder, and there were traces of bleach. But small traces of bleach could have been from an improper cleaning. But it does not conclusively mean that the grinder was somehow cleaned, that the grinder was somehow scrubbed clean to hide anything. Members of the jury, none of the witnesses today testified to you that they saw Miss Saxon killing her husband. But two witnesses confirmed that they saw Mr. Smith still alive. Detective Pickus, an investigator for more than 22 years, showed you a photograph of Mr. Smith, captured in a surveillance system in a small store in Caracas from May of this year. Miss Saxon testified that she is 100% sure that that is her husband. But members of the jury, you don't have to just believe Miss Saxon. Look at the photographs. Miss Saxon told you that she would recognize her husband, especially for the rock star beard that he had. You can determine that for yourself. Detective Pickus told you that in the course of his investigation, he was able to identify that Mr. Smith often uses Richard Spalding as an alias. Detective Pickus told you that he ran a skip trace of the name Richard Spalding and John's date of birth. And he located that the only Richard Spalding with John's matching date of birth was in Caracas. He ran surveillance checks in all common areas like grocery stores, liquor stores, and banks within a 2-mile radius of this particular Richard Spalding. And he told you that that's when he found this photograph of Mr. Smith. And to further show you that this man is actually Mr. Smith, the man signed RS. RS, the same initials to Richard Spalding, the alias that Mr. Smith often uses as he flies. The prosecution failed to show you beyond a reasonable doubt that Miss Saxon killed her husband. Now, the prosecution also had to show you that Miss Saxon killed her husband for his money. Now, we don't need to address that since the state had already failed to prove that Miss Saxon actually killed Mr. Smith. However, let's discuss it briefly, since it further shows how flawed the state's case is. Throughout this entire trial, they kept suggesting that Miss Saxon had some hand in manipulating wills or some hand in manipulating powers of attorneys. And they relied on comments made by 2 people, Mr. Jamie Smith, Miss Saxon's adopted son, and Miss Evelyn Williams, a former employee. Now, Miss Williams was interviewed by Napa Sheriff's Department back in 2000. And during that time, she explicitly said that she saw the witnesses, she witnessed the signing of the will and the signing of the power of attorney. However, 20 years after her first statement, she is now changing her tune. All of a sudden, she does not remember. You should not rely on a comment made by a person who does not remember exactly what happened. Now, Mr. Jamie Smith, who claims to be extremely fond of his father, did not participate in this investigation, not until when? 2020. That's 20 years after his father had already disappeared. Why is he appearing now and not then? It's because he's only realizing now that he and his siblings are only recovering 20% of his father's $10 million inheritance. Members of the jury, Mr. Jamie Smith did not say what he said because he wants justice for his father. No, he is here because he wants to pin his mother to a crime she did not commit so that he and his siblings can get his father's entire $10 million inheritance. Mr. Jamie Smith has 10 million reasons to lie. What's interesting is he kept suggesting that his mother killed his father. And yet where is he now? He is living in South America looking for his dad. If Mr. Jamie Smith is sure that his mother killed his father, then why is he in South America looking for his father? If Mr. Jamie Smith has reasonable doubt about whether his father is dead, shouldn't you? Today, you have many reasons to doubt because the prosecution built their entire case on conclusions based on mere unreasonable and unsupported assumptions. But members of the jury, assumptions are not enough. They are especially not enough when a person's life and freedom is on the line. The prosecution utterly failed their burden to prove any of the charges that they brought forth beyond a reasonable doubt. And because of that, the only just verdict for Miss Saxon is to find her not guilty. Thank you.
I believe that the people have reserved some time for rebuttal.
Yes, Your Honor, I believe I have about a minute left.
You may proceed.
Prosecution, you have 3 minutes and 20 seconds.
I have how much? Sorry.
3 minutes and 20 seconds.
Oh, thank you. Now, to believe what the defense wants you to believe, that John Smith is alive and living down in South America, you have to believe that he decided to pick up his entire life here in Napa, California, fly down to South America, leaving behind his $10 million of assets to the defendant, the woman who threatened to shoot him, the woman who he filed a restraining order against, the woman he was planning on divorcing, and he did so using an alias that he'd used before on flight logs. Members of the jury, that does not make any sense. Now, the defense counsel got up here and he talked about a lot of the evidence that we went over today. And I want to be clear, it's not one single piece of evidence that led to the conclusion in this case. Because members of the jury, it is all the evidence we saw today viewed in its entirety. And it's this timeline that shows the defendant's motive in this case. Defense talked about Jamie Smith's 10 million reasons to lie. Well, this shows the defendant's 10 million reasons to want John Smith dead. On March 6th, when those text messages were sent, she decided that was the end of it. And that's when she put her plan into motion. 6 days later, on March 12th, she bought that murder kit, the perfect collection of supplies to end her husband's life with their Cougars. 3 days later, she put her plan into place to make sure she would get control of all of his money through that will and the power of attorney amendment. And then finally, on March 18th, she finished the job when she fed him to the Cougars. Members of the jury, I urge you to look at this in its entirety, to look at the motive the defendant had, to look at the evidence that points to the way she carried out her plan, to remember that her husband had to disappear, but his money had to stay. And I ask you to find the only verdict that truly brings justice in this case, and justice for the victim, John Smith, because we have met our burden beyond a reasonable doubt. And the only verdict in this case that the evidence points to is a verdict of guilty.
Okay. We've now, I believe, completed everything that we're going to have today. Before we can talk about this or anything else, I believe that there's some instructions from the bailiff.
Yes,